So, welcome everyone to our virtual symposium today, Legal Dimensions of Elder Abuse in Ontario, Strengthening Access to Justice and Protections for Older Adults. We are hosting this symposium in recognition for Victims and Survivors of Crime Week with support of financial support from the Department of Justice Canada. I want to thank my team with Laura and Mary and my colleagues for helping organize this event and for all of our speakers that are participating in today's session. So I'm going to turn it over to my colleague Laura to do our opening remarks in terms of our land acknowledgement and some webinar logistics.
Good morning, everyone. We acknowledge that we gather on traditional territory of a number of First Nations and acknowledge their stewardship of these lands and its waters as protectors of its natural abundance throughout the ages. We seek a new relationship with the original peoples of this land that remains their home to this day. May this relationship be one of peace and friendship based on honor and deep respect. Thank you. So this morning, I would like to dive into some of the technical aspects of this virtual symposium. I just really want to ensure that everyone online today is comfortable and prepared to optimize this experience for all of you. So first, I want to make a note that your cameras and microphones for this webinar by default are automatically turned off. This helps us maintain the session's focus and minimize distractions for all attendees. I'm always happy to announce that we have ASL interpreters visible on screen throughout the entirety of this event today to ensure that this symposium is ultimately accessible for all of you. So for your personal viewing preference, you can choose between the speaker layout or the gallery layout so you're able to see everybody simply by clicking the grid on the top right corner of your screen and select whichever layout that works best for you. Additionally, we offer closed captioning. You can enable this or disable this feature on the Zoom account, ensuring that it meets your accessibility needs. So a couple other housekeeping points. All presentations, including PowerPoints, will be accessible on EAPO's website. This means that you can visit our website and explore the content related to this symposium. There's also going to be website links shared throughout today's session, as well as on our website. Also, we really want to encourage each and every one of you to use the chat box and share your thoughts, say a quick hello to colleagues online. It's a space for all of you to connect with other attendees and talk about your learning experience. All of the presentations will be recorded, except for our Crown Attorney's presentation will be the only session that will not be recorded today. And then finally, I want to encourage you to not only use the chat box, but if you have a question for our speakers, I encourage you to utilize the Q&A box and pose questions that you may have for any one of our speakers today. So, of course, to enhance this experience for all of you, we really want to invite you to participate in a short survey. Your feedback is absolutely critical because it's from feedback like we've received in previous conferences that we're able to deliver this one today for you. So you can submit your comments through a pop-up link that will come up after you're logging off this virtual symposium. You can also scan a QR code at the end of the event today. And then you can also, a survey link will also pop up in the chat box. So you get to pick exactly which way you want to provide feedback to each and every one of us. Respecting attendees' privacy is absolutely crucial, acknowledging that we're talking about an extremely sensitive topic today. So we encourage general questions in the Q&A box, but of course, for personal matters, please contact EAPO's head office if you feel as though you need to have that important, maybe sensitive, confidential conversation. We truly thank you for understanding uh, and trusting us leading such an important, sensitive topic. Your privacy and the privacy of every older adult is our top priority whenever we're providing any type of learning or content. And then last but not least, we have done all the housekeeping. I do want to acknowledge, and I said it in the last slide, this is obviously a sensitive topic that we're talking about. And I really want to encourage all of you to prioritize your own well-being. If some of the content's a little bit too heavy, I want you to get up, walk away from your screen, and come back when you're ready. If you need to reach out for any help or support, there's will be links in the chat box. And please, you can reach out to us at our head office as well. So passing it over to Rayanne for some opening remarks.
Great. Thank you, Laura. So good morning and welcome, everyone. It is an honor to welcome you to the symposium today and to bring a gathering of legal professionals, policymakers, advocates, healthcare providers, seniors, and community leaders who share a common commitment to ensuring that older adults in Ontario live with dignity, safety, autonomy, and respect. Today's event, as I mentioned, is with the support of Justice Canada to mark the Victims and Survivors of Crime Week. Let us use this time to reflect on how we respond and support older adults in our communities, bridging gaps across sectors, and also to raise awareness and knowledge of the justice response, services, and programs to better navigate and support older victims of elder abuse. As Ontario's population continues to age, comes sobering reality of a significant rise in the incidence of crimes against older adults. Police reported family violence and intimate partner violence in Canada indicate record high levels of violence against older adults. Since 2018, the rate of family violence against seniors has increased 49%. It's time to prioritize senior safety and security in our programs, services, and policies, and address the root causes of abuse. We have to work collectively across all sectors to prevent elder abuse. This symposium recognizes that elder abuse is not only a social and health issue, but also a legal concern. We know that many cases remain hidden, unreported, or unresolved due to fear, isolation, a lack of knowledge of the legal system, and barriers within the justice system itself, and difficulties navigating the complex processes. So throughout our discussions today, we'll examine the legal framework surrounding elder abuse in Ontario, including issues related to financial exploitation, powers of attorney, guardianship, consent, capacity, victims' rights, reporting, and access to legal support. We'll also explore how interdisciplinary partnerships between health, legal, social services, and community organizations can strengthen prevention, intervention, and protection for older adults. Effective legal protections must preserve the autonomy and self-determination while ensuring the safety and accountability. The challenge before us is to create a system that protects without disempowering, support without stigmatizing, and respond without delay. So the conversations we have today are timely and necessary. Across Canada and internationally, there's an increased recognition that justice for older adults must be strengthened through legal literacy, coordinated services, trauma-informed practices, and meaningful law reform, including Bill C-16 on coercive control. Together, we can move forward where older adults are better protected from abuse, empowered to access justice, and supported by systems that recognize their inherent value and human rights. So thank you for joining us today and joining us for this important conversation. As Laura mentioned, I encourage you to also ask questions for our inspiring experts who will be speaking today at our symposium. So I want to just give a quick run through of our aims, which I kind of alluded to. We do want to talk about the challenges, about increasing your knowledge about the pathways, about getting support, enhancing our coordination between sectors. That will come through, I think, through all of our speakers. And the next slides. And also in talking about that trauma-informed approach that how we approach and respond to older adults in these situations to ensure their safety. And again, the ultimate goal is to improve access to the legal supports. So just going quickly through the agenda today, we will, after the opening remarks, we'll start with Jason, who's on our screen, talking about prosecuting cases of elder abuse. Then we'll move into a presentation from the Retirement Home Regulatory Authority on rights of seniors in retirement homes. We'll have a quick break for people to sort of refresh, and then we'll come back talking about that financial abuse and misuse of power of attorney. And then we have a panel discussion of 3 officers from different areas across Ontario to talk about what happens after you call the police. And then finally, we'll summarize with a presentation from the Advocacy Centre for the Elderly on access rights in long-term care and retirement homes. So we have a full agenda today, as I mentioned, so we do appreciate you coming. And I'm now So it gives me pleasure to introduce Curtis Barrett, who is the Interim Director of Public Affairs at the Retirement Home Regulatory Authority. Curtis has joined us for past events, so we'll welcome him back again. Curtis has extensive experience spanning the public sector, regulatory bodies, and at all levels of government. He leads the corporate communications, media, stakeholder engagement, government relations, and strategic initiatives. Prior to working at the RHRA, he had various roles in the initial build of the new government agency responsible for centralizing public procurement across Ontario. So he is also a consultant. He was a consultant with Navigator Limited, Canada's leading high-stakes public strategy and communications firm. So we welcome Curtis for coming today to sharing information about the rights and of residents in long-term care, in retirement homes. I apologize. So I'm going to turn it over to you, and we'll allow you to share your screen. Great, thank you.
All right. Well, thank you all for having me join today. I'm just making sure that everyone can hear me correctly.
Yes.
Awesome, perfect. Thank you so much. All right, so my name is Curtis Barrett, and I'm the Interim Director of Public Affairs at the Retirement Home Regulatory Authority, and I'm joining you here today to talk to you about exploring licensed retirement homes. Some rights that we want to make sure that you understand so that you can make informed decisions, whether it's for you or for a loved one, and then how we at the regulator, our authority to protect residents. So I want to begin by setting the stage. Where do retirement homes fit within the spectrum of seniors housing? And so we know that there is a preference for folks to age in place and make modifications to your homes, like a grab bar and a washroom, for example, to support aging in place. When that's not possible by choice or by circumstance, seniors apartments or naturally occurring retirement communities could be an option. Further along the spectrum, there's licensed retirement homes, which provide care within the home by the home, which is different from seniors apartments, which may just offer meals and activities. Care could be provided externally in seniors apartments, but in retirement homes, they have the option to offer regulated care services, which we'll get into later. And then further in the spectrum is where long-term care homes are placed. And that's the continuous care model as part of our publicly funded healthcare system. And we know that there's wait lists associated with accessing that option. Zooming into retirement homes, there are generally three options available. It's independent living, where they may get a care service or two, all the way to supported or assisted living. So that's where, cost of care services could increase because the care needs are higher. And then there's some homes that may offer specialized care, like a specialized dementia care program. Fun fact, there's about 780 licensed retirement homes across Ontario with around 70,000 suites. So I want to take a moment to talk about your rights as it relates to retirement homes. And so our job is to help keep residents safe and protect their rights by enforcing the law. And that law is Ontario's Retirement Homes Act. And so in 2010, it established the care and safety standards to protect resident safety and well-being. It also created an independent, not-for-profit regulator, the Retirement Home Regulatory Authority, who has the authority to take action by licensing and inspecting retirement homes, enforcing care and safety standards in those homes and residents' rights, as well as educating the public and raising awareness of residents' rights. So what is a licensed retirement home? And so there is a definition under the Act. It is a residential complex or part of a residential complex that is occupied primarily by people who are over the age of 65. And it has to be at least 6 people. And they cannot be related to the owner or operator, or else they're family, they're not tenants. And what makes retirement homes unique is that they're offering at least 2 of the 13 regulated care services. Like I said, if it's a home that is offering meals and activities for older adults, and maybe they're getting care provided externally by, let's say, Ontario Health at Home, that's not a retirement home. If the home is offering and doing the care services themselves, then that's when we're getting into a space of a retirement home, and the Retirement Homes Act applies. So what are those 13 care services? Well, I'm here to tell you. There's meals, there's a help with the medication, there's dementia care program. I'm not going to go through the whole list, it's on the slide, but there's a few things that I want people to understand when it comes to care services. Number one, don't assume that all retirement homes are the same. They actually can be quite variable in the types and amount of care services that they offer. We also want people to know that you don't have to buy the care services from the retirement home. You do have the option to be assessed and receive care from an external party, whether that is private pay or government funded like Ontario Health at Home. When you're looking for a retirement home for you or your loved one, we also want to make sure you're thinking about not just your current care needs, but also your future care needs. I'll give you an example. So let's say I have a family member, I'm moving into a retirement home and they have early onset dementia. And I recognize that as they age, their condition will likely get more acute. It'll likely get worse. And so in those circumstances, I will likely want to find a home that offers a dementia care program. Because if I move them in, they didn't need it right away, and it wasn't there, well, when they eventually need it, I may need to move my family member out of that home. And doing a move, especially in the later years in life, can be really disruptive and avoidable, if possible. And so that's an important tip we like to tell people. And of course, there is always a possibility that there could be wait lists for certain care services, maybe the dementia care program or services from a physician as an example. And so it's always great to ask if there are any wait lists for the care service, or if there have been in the past wait lists for the care services, just so it's more information at your fingertips, so you can consider that when you're moving in. Oh, I might have access, but I may need to think about this if there becomes wait lists for these services. There's a lot of information on this slide, and it's used as a tool just to help at a high level, general level, explain the difference between seniors apartments, licensed retirement homes, and our long-term care homes. What you'll notice is that the acuity typically gets more advanced as you're moving from left to right. And you'll notice that the care services, are ramping up as you're moving from the seniors apartment all the way to long-term care. Where I want to focus on is the safety and oversight. So generally speaking, with seniors apartments, there are tenants, And so there's the Residential Tenancies Act, and it's the Landlord Tenant Board to support them. When it comes to licensed retirement homes, it is the Retirement Homes Act when it comes to the care and safety standards of the home, and that's overseen by the Retirement Home Regulatory Authority. But when it comes to tenancies matters, like the cost of care services, as an example, or anything maintenance or other details that form part of your tenancy agreement, that is the authority under the Residential Tenancies Act and Landlord Tenant Board. And then, of course, Ministry of Long-Term Care, which are not retirement homes. They're overseen by the government, by the Ministry of Long-Term Care. So again, just to point this out with the Residential Tenancies Act, this came before the Retirement Homes Act. Again, this covers all the care service cost increases, maintenance, or other tenancy rules or challenges. And it's the Landlord Tenant Board that handles those concerns. When it comes to the care and safety standards that are being provided in the home, that is the accountability of the Retirement Home Regulatory Authority for overseeing that. Now, there is aspects of transparency and notice when it comes to care service fees in the Retirement Homes Act. And so they must provide retirement homes to residents and family members the price list for accommodation, care services, or any extras, as well as 90 days written notice if there's going to be any changes to the care services, if they're taking away or minimizing the care, or if they are increasing the cost, as an example. And you can always ask how often and by how much they've raised rent or care service fees in the past to help you anticipate any future expense planning. And so we tell people to think of licensing like an insurance policy. You hope you will never need it, but it sure matters a lot, when you do. And so it gives the public confidence that the residents, that the home is prepared to keep residents safe and that residents are being protected and that there's oversight. And so they must follow the Retirement Homes Act. They have to be regularly inspected by our inspectors. They have to maintain clear complaint processes and emergency procedures and test those emergency procedures like real fire drills, real evacuations, so that it's not the first time they're doing it or practicing it when it really happens. They also have to uphold the Residents' Bill of Rights, and they may also qualify for financial support through our emergency fund if they're living in a licensed retirement home and there's problems. We'll get to that later. So just on the Residents' Bill of Rights, when you're walking into a retirement home, you should see a Residents' Bill of Rights posted. You should see all recent inspection reports, and you should also see the RHRA license in the front lobby in a publicly accessible way. And so the Bill of Rights becomes part of your tenancy agreement. It has all sorts of considerations like what care services are provided and to know how much they cost. A copy of this Bill of Rights is available on our website as well if you want to read it in full. So when it comes to financial protections under the Retirement Homes Act, as part of our licensing activity, homes must have extra expense insurance. And so that is to cover at least 120 days coverage if the home has to abruptly close. The example I can give is because of a fire or a flood. So it needs to be appropriate alternative accommodations and care for those residents, so they're not just left out to their own devices. If the residents incur expenses and the extra expense insurance of the retirement home operator doesn't cover all those expenses, that's when the emergency fund from the Retirement Home Regulatory Authority comes in effect. Think of extra expense insurance as the backup plan, and our emergency fund is the backup to the backup plan. So it's around, typically $3,500, but up to about $10,000 is the maximum limit, depending on the circumstances in the case. And the emergency fund is funded through the penalties paid by retirement homes. So if there is non-compliance that we're noticing it's severe enough to apply a penalty, we can't touch that money. That money goes straight to our emergency fund and can only be used in these emergencies to support residents. Now I want to go through some information that we make available on our website to support your informed decision making. And so we have our database. And so I posted a little link in the chat for a link straight to our database. And so every licensed retirement home is listed there. So here's the tip. If you don't see the home there, then it's likely a senior's apartment or long-term care, or it's operating unlicensed, which we can talk about. But if it's not on our database, then it's not a licensed retirement home. And so you can use this to find local retirement homes in your area, confirm that the home is licensed, check their compliance history, you can look at their inspection reports. You can also filter by care services. And we just tell people, check before you choose and make sure that you're thinking about not just your current care services, but the ones in the future. And so here's just a little image of our database where you can filter by care services. It also has a map function where you can look at your local neighborhood to see, is there any retirement homes close? I know if I'm ever, considering one myself or in the future or moving a family member into one, I'd want them to be close to home. And then you can make informed decisions by reviewing the information that we have available on those retirement homes. So once you click into a retirement home, you can look at the care services they offer. You can take a look at the public inspection reports. What were the allegations being made? What were the findings? Have we taken any enforcement orders or enforcement decisions, action against the home? Have we placed any conditions on the license? And so these are all things that you can take a look at so you have more information about the retirement home that you might consider touring before you go in through the front doors. And it could also give you some prompts for questions to ask when you're doing a tour. We also provide a lot of helpful resources on our consumer support hub, and so I've also posted the link to that. And so it's got information about our current residents, a little information booklet, as well as one for those who are considering a retirement home. You have different information needs at different stages of your retirement home journey, and we're trying to appeal to that. We also have frequently asked questions, some fact sheets, tips for finding the home. So lots of information there to take advantage of. We also know that the diversity of Ontario is, of course, increasing across the Great Province. And so we've made sure to translate some of our materials in various languages. And when we implement our new website later this year, we're going to be using AI for auto translation to make things even more accessible. So now I want to talk to you about the authorities that the RHRA has to protect residents. Generally speaking, high level, we license retirement homes, we inspect them, we respond to concerns, and we enforce compliance. So again, licensing gives consumers confidence that the facility itself is prepared to keep residents safe. And so key requirements include, a fire safety plan. We want to see the food handling certificate. We want to make sure that there's an information package that goes out to residents and it has all the information needed in there. The extra expense insurance that I was explaining before. These are all things that we make sure are in place before we can license a home and before residents can move in to make sure it's prepared according to law to keep those residents safe. So a home is licensed. Now it's subject to inspections. There's two types of inspections we do, routine and responsive. By law, we are required to inspect a retirement home routinely once every 3 years. Now that sounds like a long time. Depending on the non-compliance or history of the home, we may be visiting those homes more often. So if we see that there's issues in the home, we're going to want to monitor that more closely versus a home that might have residents who are mostly independent and we haven't heard any concerns from them and previous routine inspections have been completely clean. Well, then we may not be visiting that home as often as one that is the opposite, let's say. If we ever receive a concern and it meets the threshold where, we want to send an inspector to go check things out, that would be our responsive inspection. And that can be a response to complaints, reports of harm, which I'll get into in a second, and then as well as any unlicensed retirement home tips. And so for service members and members of the community on the call today, that's one ask is, if you're in a facility and you're seeing that care is being provided or looks like it's being provided by the home, but it's not a licensed retirement home, you don't see it on the database, we'll take the tips and we can even take them anonymously. If you ever suspect that a facility is operating as a retirement home without a license, please let us know. Last year, I think we got about 16 tips or 32, somewhere in that range. So after an inspection, depending on the results and compliance, it would determine our next steps. And so we follow up, we'll do one-on-one support. We may follow up with the home if we've identified issues and we just want to make sure that they've been fully addressed. We'll inspect a home more frequently if there's ongoing risks, like I said. And of course, if a concern is unaddressed or if it's serious in nature, we will of course consider enforcement action. So raising a concern. There's two types. There's a formal written complaint that has a decision letter by our registrar, and then there's reporting harm. So when it comes to reporting complaints or concerns, we always encourage people to start by talking to the home. The home must have the transparent complaints process, and they have to investigate and respond to your concerns within 10 business days. If you are unsatisfied or you feel like your concern has not been addressed, then we encourage you to give us a call or contact us, and we can help you work through our complaints process and advise. Speaking up is your right, and I understand that our complaints process isn't anonymous, because for us to be able to work with both parties to reach a resolution, we need to know of both parties. And so we're unable to process complaints anonymously. Reports of harm are different, which I'll talk to next. Examples that we've received in complaints could be, medication administration errors, or, behavior management of other residents, or, potentially, allegations of emotional abuse. Report of harm is different, and it's not just reporting harm, it's also reporting risk of harm. By law, all retirement home operators and staff are required to report harm or any risk of harm that they've witnessed or been involved in. And the community members, service members are also able to use this option, and this can be anonymous. And so, again, we receive reports of harm from staff, but we've also received them from police. We've received them from ambulance, paramedics, firefighters, PSWs, the list can go on. Anyone is able to file a report of harm that goes straight to the RHRA, and you can also, again, do so anonymously. I'm going to give you an example because it's not just harm, it's also risk of harm. An example of risk of harm, let's say a resident goes out a back door and it locks behind them. And, that shouldn't have been possible, or there should have been an alarm. Well, let's say it's a beautiful day outside, the weather's great. Well, then that shouldn't have happened. That's a risk. But, nothing wrong happened. The person wasn't injured. Good, thankfully. What happens if it was minus 40 outside? Well, then that's a different circumstance, but the same issue could have resulted in a much different outcome. And so that's why it's not just harm, it's also risk of harm. If you're ever unsure, give us a call, send us an email, and we're happy to help. So, concern has been brought to the regulator, and let's say we've assessed it, that there's enforcement action that is possible that we can take. I'm going to walk through our different toolbox. So license conditions is a condition we'll place on the license either at any point in time or upon licensing. And an example could be we want someone acceptable to the RHRA with a certain amount of experience. Let's say someone trying to get a license has great older adult facilities maintenance and management, but they may not have someone with strong enough experience overseeing the care that's being provided in the home. Then we might put a condition on the license saying, hey, we want someone acceptable to the RHRA with a certain amount of qualifications, education requirements to oversee this. And that is to help safeguard the resident safety and well-being, and conditions are monitored by the RHRA. The next one is the compliance order. And so that is when we're telling a retirement home to do something or to stop doing something. An example could be we've done an inspection and we've noticed that there is a lack of training or mistraining by some of the staff. So then we could say, hey, within this certain amount of time, we'd like you to have these staff trained. We want it to see who's doing the training. They have to be acceptable to us, and we'd like to see the materials in advance. And then we want the attendance list afterwards, as an example. A management order is when we've lost confidence in the operation of the retirement home, and we've placed someone that we trust in there to oversee the operations and keep those residents safe while we deal with the non-compliance of the operator. An administrative penalty, we can penalize up to $10,000, depending on the severity of the circumstances. And again, that all of those funds go straight to our emergency fund. We're not able to do anything with the penalties. License revocation is the last resort. This is serious in nature. This is when an operator cannot or will not follow the law. And if you cannot or will not follow the law, you cannot operate a retirement home. And this is our more of a last resort option because in most cases it means that the residents would have to move, and that can be extremely disruptive. And so we're, trying to weigh options in the spirit of the well-being of the residents when we're considering license revocations. And then when it comes to prosecutions, we do have the ability to prosecute under the Act. And in some cases, we have taken operators who've broken the law to court. So it's not just about reacting when concerns are brought to the RHRA, it's also about being proactive. And so we even have a function at the regulator, a licensee engagement and support team. And so they'll proactively work with retirement homes to give them support and guidance to help prepare and equip them to succeed in protecting residents. And so instead of coming in after the fact and say, hey, this is how you could have done things differently to prevent this from happening, let's work with them at the beginning of the process to even help prevent those things from happening in the first place. You'll also see us across the community. I'm going to give a shout out to the Older Adult Centre Association of Ontario, who organizes seniors fairs with the in collaboration with the Government of Ontario. So we love to join those. I've also seen Elder Abuse Prevention Ontario at them very often. And it's a great opportunity to connect with us, ask questions, and get some more of those physical materials that's available on our consumer support hub. So we're always happy. And so for service members and community members, if you'd like for us to come and speak to your organization or have more of a specific conversation, maybe more in the weeds around the legalities of the Retirement Homes Act, or speak to some of our enforcement folks, I'd be happy to help organize that for you. And that brings me to the end of my presentation. And before we open it up to questions, because of personal privacy, if there's any specific concerns, I'm not going to be able to address those in today's conversation. If they are specific in nature, I always encourage you to call us at the RHRA. I'll put our contact information up next. And this is where you can reach us. We do have a little QR code. I'll keep this up while I answer questions, if that's okay. I encourage you to take your phone, open up your camera, look at the QR code, and click the link there. It's over to a survey, just a couple of questions, and it's asking if you're leaving today's with a stronger understanding of your rights as it relates to retirement homes. Thank you so much.
Great. Thank you so much, Curtis. Well, we do have a few questions from our participants today. One was talking about that does the RHA proactively review retirement homes, like do a surprise visit for inspections, or is it only when there's a complaint that's posed?
So we have those two types of inspections. There's a routine inspection, that's the proactive one, and it's unannounced. And then we also have responsive inspections. So if someone shares a concern with us, sometimes we might be able to reach out to the home to gather information, but depending on the circumstances, if it's more serious in nature, then we can do a responsive inspection. And again, those aren't announced.
Okay, thank you. And if someone is concerned about, the conditions, or maybe they see there's some neglect in terms of the way that a home is properly caring, or just the environment that's not cleanliness, or there's bed bugs, for instance, they would just report that directly, and then that would be investigation would take place.
So you can give us a call, or you can fill out the report of harm form that's on our website to report a concern to us.
Great. And just to clarify that what Curtis is talking about, this only refers to the retirement homes and not long-term care homes. That's under a different ministry. So just clarifying that.
Thank you, Rhiannon.
Someone was just asking you if you can clarify the difference between RHRA and ORCA, which is the Ontario Retirement Communities Association.
Yes, ORCA is the Ontario Retirement Communities Association. So they're the industry association representing the vast majority of retirement homes across Ontario. What we are is the Retirement Home Regulatory Authority. In 2010, the Retirement Homes Act was created to fill a gap and to establish safe care and safety standards for retirement homes, and it created the Retirement Home Regulatory to enforce those standards. So we're not part of government, but we're a creation of a government, and we're an independent, not-for-profit organization.
What happens if someone, goes into a retirement home and they indicate that they're going to offer different services like memory care, and the home, once they get in there, decides or does not offer that service that they initially indicated that they provided?
So that's where we want to make sure that you look on the retirement home database, because when a home is licensed, they need to share with us what are the regulated care services that they're offering. And so if you're seeing a home that has offering memory care, but when you go on their database, there's no dementia care, which is the regulated care service. I know we use different words for different things, but for dementia care, then that might be a question you'd want to ask the retirement home.
Great. And I also had a question about the emergency fund that you had talked about at the beginning of your presentation. So if a home is non-compliant for many reasons and it escalates to the point where a retirement home is, let's say, shut down, would that emergency fund then help residents if they had to relocate to a different home, or is did that money separate? Is that a different situation that the money would be allocated for?
If it's an abrupt, so when a retirement home is closing, they have to provide 120 days notice, both to the regulator as well as to the residents and family members. Like that is the law. And so the emergency fund kicks in when people can't meet those obligations because of, let's say, there's a fire or a flood. But if a retirement home says, you know what, I'm packing up my business, I don't want to run this retirement home anymore, and says you got 20 days to move out, that's breaking the law. And so in that case, our emergency fund would come into effect. But if it is a planned shutdown, the vast majority, I'd say more than 90% of retirement homes are for profit. They are businesses. And so if they decide to shut down and that they no longer want to do business, that is their right to choose to do that. They have to provide 120 days notice.
Great, thank you. We just had another question. What happens if a retirement home does not receive approval to be regulated? Can they still function as one?
So if a facility applies for a license and they don't, and they're not licensed, let's say, for whatever reason, they can still be a senior's apartment, so they can still have tenants, but they're just not allowed to provide the care themselves. So that's where Ontario Health at Home or private pay external care providers can come in and provide those, or family members can provide those care services to the residents. That's totally fine because it's not the home providing it. And again, that's where the Retirement Homes Act and the authority get involved, because it's about what are the safety and care standards of the care being provided there.
Okay, I think we have one last question that we have time for. Question about fees, which is always a question, I think, for lots of people. Are the fees regulated by the RHRA?
So no. Fees, rental or care services forms part of your tenancy agreement, and is therefore, if there's concerns around that, it's the landlord tenant board. The Retirement Homes Act doesn't regulate the cost of care services, but what it does do is provide requirements around transparency and notice. And so if they are going to increase the fees on the care service side, they have to give you 90 days notice. And they also need to give you a full price list for transparency and including any care accommodations and extras.
Great, that's very helpful. And I think just people understanding about the different the Landlord Tenant Act, that retirement homes do fall under that act as well. And just understanding, because it is a tenancy, and a lot of people don't maybe see it that way as well. So knowing that they have that option as well to help them and legally as well. So we want to thank you so much, Curtis, for spending time with us. As always, appreciate your informative insight in terms of even the rights, the laws, understanding, reporting. I know that you're updating the website and looking forward to that. And there's lots of information, and encourage people to do check out the links on the website. There's a lot of great information, plain language that people can access, as well as it's translated in multiple languages for accessibility. So thank you again for joining us, and we hope that we can collaborate again in the future. So we are now going to take a short 15-minute break for people to stretch, get a coffee, whatever, and we will come back at 11:45, and we will have our next presentation by Detective Mike Payne, who will be talking about financial abuse and powers of attorney, which I think is a hot topic for lots of people to understand how the POAs and the police response to that. So we'll take a quick break and we'll see you back in 15 minutes. Thank you. Hi, Mike. Just wanted to let you know that we can see your slide deck, so which is awesome. And we will see you in
people on this presentation and on this symposium. So I'm going to try and keep it to a level for investigators, seniors, older adults that are involved with us today or joined us today, as well as practitioners and hopefully some prosecutors. I know you had a keynote from our friend Jason earlier this morning. So I'm going to share my screen now. And my presentation should be about 20 minutes or so, and then we'll have some time for question and answers. Okay, so when given this opportunity, we're going to speak to financial abuse and misuse of power of attorneys. And I have to give always a caveat. This is the police perspective. It is a complex civil matter, family estate matter, governed by different acts. But what we're going to focus on today is a high-level overview of power of attorneys. Then I want to drive right into the police perspective. What does that look like for an investigation? And more importantly, the challenges we're seeing, give you some thoughts on the current state of prosecutions and where do we need to go, I always say as a community. We can certainly say in the world of fraud, and I'll wear two hats a little bit today, we will not prosecute our way or charge our way out of the issue. And as we've lived this for many years, all the champions and stakeholders in elder abuse, this is a community response. And we need to make sure that there's many eyes and ears on these situations. So again, I wear the Waterloo Regional Police hat, but as Elder Abuse Prevention Ontario, we have elder abuse prevention councils and networks all across Ontario. I'm the chair and very proud of our local Waterloo Wellington Elder Abuse Prevention Council, and we have a robust group of volunteers. I would encourage anybody who's on this call, seek out your local elder abuse network, get involved, be a volunteer. Get involved in the education, the prevention, and any of the campaigns that are run by the networks. We're going to talk about understanding the power of attorneys. What is a power of attorney? I will get into what acts govern and what acts carry these documents, but a power of attorney is a very important document that authorizes a person to act on another's behalf in a specified decision area, often in cases supporting those in need or assistance. The document on its face, the scope of that document, is where we see some problems. Once it's signed, it could be enacted, but we also have issues where we don't have any controls in the power of attorney documents. There's two types of power of attorney documents. There's power of attorney for financial affairs or property and personal and healthcare decisions. Each are have distinct legal requirements and protections. Anybody, a practitioner or an investigator involved, must understand both hats of those legislations, those acts. They're not easy reads. The The world of online access to these acts make it easier to comprehend and possibly get the information that you need. But without understanding what these acts do and the authorities within these acts, especially as people entering into these power of attorney documents, we run the risk of abuse. Proper understanding can prevent and ensures respect for the person entering in to these documents, supporting the lawful decisions that they're making, a guide for the grantor to the attorney on how these decisions are to be made. Let's focus on power of attorney for property and finances. This is a document that helps us manage our accounts, real estate decisions, investments, and these documents can have terms and restrictions. Often we don't see any terms and restrictions in these documents. The POA will become effective immediately once it's dated, witnessed, and signed. This creates risks to the grantor. The grantor is the person asking someone to act as a power of attorney, an attorney for them. We're going to always have the conversation of capacity. We see capacity concerns in our cases. I'm not today, unfortunately, going to be able to go too deep into capacities and incapacities. There's always a need for further education and resources to understand what that looks like. But basically, it's the person before the grantor understanding, does the person have the clear direction and understanding of what they're entering into? What we run into in our cases is conflicting documents, multiple power of attorney documents, documents entered into by financial institutions, investment firms, as well as the standalone type of documents that you see from law firms. And with that, conflicts are going to arise. Power of attorney versions without clear revocation guidelines. And we all know in our cases, strained family dynamics complicating decisions. How do we safeguard against abuse? Professionals, this is where I'm speaking to you. The red flags that we should know are from our clients. Sudden changes, joint accounts, power of attorneys on accounts, large cash withdrawals. Recently, I have a case where the attorney, let's say, wanted to be attorney, went away from the home branch with his parents to a secondary, or let's call it a branch, a long ways away from the home branch, trying to set up power of attorney. The staff at this branch, this financial institution, were alerted to this. Why wouldn't you go to your home branch? They did not act on the request of the son. We're continuing to investigate, and there's some coercion in regards to that change and that request. Another flag is secondary cards on accounts. Web access when the older adult is not familiar or does not understand how to use online banking products. I must touch on the power of attorney for personal care. Remember, personal care, power of attorney, is for health and well-being decisions. It's not for financial decisions. And where I've seen challenges in my cases over the years is older adults entering into their estate matters, remember their wills, and somewhere in the back, they're throwing in continuing power of attorney documents, sometimes personal care, sometimes for property. When we do investigate, usually the first thing I get is I need to see the documents, the power of attorney and documents. Often what I get is I get the wills. So there's that education right at the front end. What kind of documents are we using? What kind of documents do we have? We know power of attorneys for personal care usually require capacity assessments to ensure the decisions are being made with dignity and autonomy. Let's talk about where do we come from? Professional responsibility. How do we have this? These power of attorney documents. Remember, these are from certain acts in Ontario. If we just backed up to where we just came from, each province across Canada, because I'll speak to everyone on this call, has different types of legislations to govern power of attorneys. In Ontario, we have the Substitute Decisions Act. The SDA, as we call it in our business, governs power of attorney for property, also personal care, detailing capacity, execution, and attorney's duties. Also in our power of attorneys, the Healthcare Consent Act in Ontario talks about medical treatments, healthcare decisions, outlining who can give or refuse consent. These acts provide clear direction and oversight on what these documents and these attorney documents should look like. Speaking to the practitioners on this, we need to know your client because we have that fancy word fiduciary duty. We must act as a trusted advisor, no signs of abuse, the complicated matter of undue influence or incapacity when working with power of attorney. We have to look further into out of normal red flag transactions. We know that we could be held responsible for not acting in the best interests of our clients, given all the responsibilities before us. We need to validate power of attorneys when they're before us to all the practitioners here. Just someone saying that I am the power of attorney, we often get that on complaint to police services, is not enough. You have to see the document, look at the document, and see what the conditions or possible restrictions outline. Let's talk about something that's close to what I know in all the years of dealing with these matters. I've probably investigated, not charged by any means. There's a low threshold of charge in elder abuse cases, and that's a good thing. Probably about 400 to 500 cases. So let's speak to some of the things that we know. Our investigations must be evidence directed, but more importantly, evidence and victim directed. In investigations involving elder abuse, and I'm speaking to ones where there's capacity to make decisions, capacity to direct the investigation, we must seek the direction of the victim. In Ontario, there is no thou shalt charge in elder abuse cases. We must be investigators to gather documentary evidence to support the case for the Crown's prosecution. That includes judicial authorizations to banking records, medical records, and if capacity is in question, possibly obtaining medical records related to capacity or incapacities. Something that's exciting over the past probably 5 to 10 years in my role with LEAPS, the law enforcement agencies partners protecting seniors and older adults, and working with OPC, is the new information for the investigation of older adults. Through advocacy with LEAPS and OPC, Ontario Police College, we have better tools to interview older adults when it comes to understanding their reliability, their capacity of what they're telling us. Our investigations will include interview of victims, caregivers, physicians, and witness. We will often use audio and video statements for comprehensive fact-finding. I call it in my business, I need to rule out all the noise. I need to get direction from the victims. I need to seek evidence to support what I'm dealing with. Am I dealing with a family dispute? Most of the times I am. Or is there true criminality here? And as a police officer and investigator, what is the best course of action? These investigations are complex. As my colleagues on this symposium today would relate, we don't charge very often. There's many reasons for that, but usually the number one reason is the victim, often a family member, does not want to criminally prosecute their family member, a son, a grandson, a daughter. All families have stories, and we know that. There's history of mental health. There's history of substance abuse. There's history of abuse through the family. They don't want to move forward for a criminal prosecution, and ultimately we respect that. We do put in place lots of supports. We do put in place referrals to other agencies. But as you can see by this slide, at all points, we're talking about victim-directed investigation. Even at the challenging prosecution stage, we are victim-directed. I've had cases where the elderly older adult has said, Mike, I can't continue on with this. And the Crown and I would have to have a hard conversation about withdrawing or staying the investigation. or the prosecution, or entering into a peace bond. These are really challenging. We have to put in victim supports during our investigations, and just as important is during our prosecutions. It could be victim support agencies, it could be social work programs to help the older adults stay the course in these complex and difficult prosecutions. Many times we hear, what does the police response look like? And yes, I've shown uniform icons here, or uniform avatar imaging here. But often in some places across Ontario, we do know that there is a uniform response. Uniform response is patrol response. Sometimes it's a specialized community engagement response. Due to the needs of the community or the resources of those communities, those are often the only way that elder abuse, older adult investigations can be responded to. There are general investigation response, and less general investigations now we're into more of a plainclothes capacity. We see that with more complex cases. A plainclothes response could be a fraud unit like ours, dealing with cases that are over 25,000 or 100,000. Or recently, I have a case that I'm working through is $350,000. We do know, and I worked on specialized teams where they are partnered with a Ontario Health at Home social worker or nurse type program. These dedicated teams are trained, modeled to respect the older adult's direction, and they have skills and abilities to manage the complexities of older adult elder abuse investigations. I know Hamilton was one of the first a long time ago. I sought advice from them when I first started this way back in 2006. Ottawa has had a switched on robust program. Halton, as well as Waterloo Regional Police Service, which I was a part of. It's called the Senior Support Team, a partnership with Ontario Health at Home Home Care. It also was once called the Elder Abuse Response Team. There's officer liaisons throughout Ontario who would deal with older adult matters or senior issues. So there's different police response across Ontario. This can be very frustrating to families, prosecutors on the different models, but there's no standard approach across Ontario. What do we look at when it comes to the offenders, the offenses, and outcomes? Remember, these are not unknown persons investigations. These are trusted persons, family members, care workers, or advisors, sometimes power of attorneys. Sometimes they just get the trust of the older adult and they become joint on account. They become joint with cards. But today, for the purposes of today, we're speaking to power of attorneys. The type of offenses that we do see, and I want everyone to know, it's not just a civil matter, and I'll speak to a really high level, really important case law that came through in 2026 about this. These are crimes: theft by person holding power of attorney, Section 331 of the Criminal Code. There's straight theft. There's breach of trust. There's fraud over and under. There's possession of credit card data, which we often see when someone takes the credit card just to get the older adult some groceries, but then they buy OLG gaming products. And robbery. What do you mean by robbery, Mike, you're saying? I had a case a couple of years ago. Highly drug addicted son was hitting his mother for the debit card. He actually would strike her when she would say repeatedly no, no, and no, to the point where she just gave up and gave him the card. We were able to establish that he was striking her to get the debit card. Therefore, we were successfully able to lay the charge of robbery. What are our investigation outcomes? I wish I could say they were always 100% successful. I wish I could say that we successfully prosecuted all of these cases, but we don't. Our prosecution rate, because of the mentioned reasons, is very low. We may be charged 2 to 3% of all our cases. Therefore, we're probably lower prosecution level. We try and find resolutions. In the current state of prosecutions, even more options are being looked at for resolution. We will put bail conditions on power of attorneys, limiting them from acting as a power of attorney, if not only for the grantor, anyone in a vulnerable population, which puts them on terms not to act as an attorney in any way. We've worked closely with the Crown. These are terms that we're using to make sure that the vulnerable population, older adults, are protected. We also are asking for restitution orders in cases where we do have matters that are where convictions are registered. It'd be amiss if I didn't talk about the challenges, and I've hinted at as I've come along this presentation today. I want to touch on the case law side that's really exciting and something that came to light this year, and then ultimately the prevention. Our challenges, we're having real-time challenges with the prosecution of cases, and that's in any non-violent crime across the province. I know Jason could probably speak to this and the challenges that MAG is facing with limited resources, staffing shortages, court time constraints, and the amount of shortages for attorney capacity, which hinders prosecution of power of attorney abuse cases. This is not new, but we are at a bit of a crisis point, and this is from an investigator looking in, dealing with the system at this point. We have to find other ways to get resolutions in these matters, and we need to continue and revisit the restorative justice approach to resolving these families in dispute, these power of attorney, these elder abuse matters. Restorative justice has great merit in resolving these matters. It's what is that going to look like? What agencies are going to help facilitate working with the Crown, the family, and the investigators to move forward those restorative resolutions. As I mentioned, I want to speak to the significant case of R versus Earhart, an OPP investigation going back to 2022. R versus Earhart in 2026, Ontario Supreme Court was a jury conviction. To me, it was groundbreaking when it came to a common law partner holding power of attorney over a victim with Alzheimer's type dementia. This accused, then convicted, had exercised total financial control. But the courts convicted this individual of theft by power of attorney and theft over $5,000. The court rejected, and it's often the case, this is just a family dispute, a civil matter, and put full criminal accountability for coercive control and financial exploitation through a power of attorney. What was, to me, significant was the fact of screening cases when it was a common law or a marriage family law type matter. We often found ourselves directing those individuals to a family court type of process. This gave us some guidelines, and it's not perfect, but gave us good guidelines in these common law type matters where we can successfully charge and possibly criminally prosecute for the offenses mentioned. The fact that the court recognized that a family dispute or arguments wasn't just something that should be taken lightly and there was full criminal accountability is a big win for the courts, the prosecutors, and police across Ontario. I want to shout out to Whaley Estates Litigation and Partners, Kimberly Whaley, who's a big partner of all elder abuse supports and education, teaching at OPC, and her team has been an advocate for these type of matters going back decades. So congratulations, because Kimberly and her team made this a highlight in a lot of their media releases and their bulletins. So thank you to Whaley Estates Litigation for those high-level notices on that case law. We have to also talk about, so the police investigations and the court prosecutions aside, what other parallel investigations do we have? Let's not all forget here, the Office of the Public Guardian and Trustee, they have an investigation unit which could look into these investigations. We have internal investigations on complaint to banks, care homes, and businesses. We also have the human resource investigations. If we have a worker, a care provider working outside of guidelines or standards of procedure. Documents from criminal investigations, court processes can be used on application in these investigations. We know the Ministry of Health and long-term care investigation teams and units, the Fixing Long-Term Care Act. There's some growth in those investigations and can be involved. As we saw earlier today, the Retirement Home Regulatory Authority, they have an investigation unit of inspectors and investigators that can be involved. And we cannot forget the professional associations that they have their own investigative bodies, nurses, occupational therapists, physiotherapists, and physicians. You'll notice absent in these investigations is a governing oversight regulatory body for the massive cohort of personal support workers and this new level of healthcare workers at home. We need more lobbying, we need more legislation to support regulation for that body of workers who are in our older adults' homes with understanding of the eyes and ears of abuse and the importance of having proper regulations or regulatory bodies for those workers. As we wrap up, what do? I want to talk about some prevention, some practical tips, and some developing services. It's a shared responsibility. It's not just the police, it's not just the lawyer in regards to power of attorney abuse. It requires cooperation and conversation between older adults, their families, all the professionals, and the institutions who are involved in using these documents or drafting these documents. Practical safety measures, safe banking practices, informed decision-making may reduce the risk of financial exploitation. The conversation about not giving up your PIN, not entering into joint accounts needs to continue to be had with older adults on why are we doing this, because the risk of abuse can be great. I know that our friends from the Ontario Public Guardian would say you can download the document on their website and create a cost-effective power of attorney document. It's free. I'm an advocate and promote that power of attorney must and should be drafted by lawyers. They should be regularly revisited and granted and entered into with clear instructions and understanding. Some things that we're seeing in the ongoing development of where are we going with these type of matters and investigations. If we take a look at the Canadian Centre for Decision-Making Capacity, and I've kind of captured it here, www.incapacityliteracy.org. It's a one-stop shop for a power of attorney registry and capacity clinic services, which will help older adults and people entering into these documents have a better understanding of what they're entering into, and it will help prevent exploitation. These are new products and new services that are out there in Ontario, and that they could be used to better situate families to understand what they're entering into. And when those documents are entered into, a registry where we can go and look at it as investigators, where we can go get it with lawful authority to understand what we're dealing with when there's a complaint. So that is my presentation for today. I've been going for about half an hour. I'm more than welcome to answer any questions that's needed, and I'll stop sharing my screen right now. I can answer any of the questions in the chat group.
Absolutely. Thank you so much for your presentation. And let's just jump right into the questions that we've been getting in the chat box here. So I did pull one up in regards to the seen benefit of, so the question reads, would a registry of POAs be helpful to avoid multiple and conflicting POAs and to prevent somebody from being POA who is being barred from doing so? So maybe you could talk more about the potential benefits of actually having that.
Great question, and it's something that's come up time and time again at the provincial level in Ontario. It's now we're seeing, there was a private members bill a lifetime ago. Members of the LEAPS group were involved in advocating and supporting that, where a private members bill talked about a registry. It fell off at first or second reading. The ministry, and I'm speaking just from my knowledge of that situation, not have the appetite or the resources or ability to come up with a comprehensive large database. So we're seeing, as I mentioned in my last slide on prevention, private type registries and private type services where we need to drive up a need for a registry, because registries are important. They prevent that duplication. They prevent that this one is valid, this one isn't. There's a one-stop, let's call it shop, where we can find the document that is on file. Very problematic because we'd have many stakeholders that need to be involved. It could be the banks, could be the lawyers, but these products can certainly help in adding clarity to the documents that are before us.
Absolutely. So on to the next question. Is there anything I can do as a community agency to gain better access to POA documents if a POA is refusing to show it?
Fortunately, no. There's nothing that can compel someone to show the document. Often that smoke and mirrors is a big indicator of abuse, power and control, and that's where we need to activate specialists, possibly at Ontario Health and Home, or specialists within law enforcement, those specialized teams, to do some inquiring in regards to this situation. There may be a legal approach, a lawyer, and of course that comes with dollars and cents, asking for that document to be produced. If the person's verbally acting, they should produce that document, but they are not compelled to produce that document.
Mm-hmm. And big surprise, another POA question for you, Mike. What happens if the named POA is currently incarcerated?
Very challenging. I have never had that case, but it could happen. They are still, and that's why we have to be careful with who we choose. It just does not have to be a family member. It needs to be someone who should be available, accessible, I would say of good standing. I have seen cases where family feel and parents feel that they are compelled to provide it to a family member, son or daughter, who has struggled with substance abuse and their own financial challenges. We're of the opinion when we look back on that and speak with them that they now realize that that was a bad decision. So if they're incarcerated, I would hope there would be a secondary on that document. If they're unavailable, and especially when it comes to healthcare consent, there is a hierarchy of decision making. So that's the healthcare consent for decision on health matters. When it comes to property, I'm not familiar with a clause that allows anyone to act on behalf of someone when it comes to property or finances in absence of someone else. That grantor, though, could, in absence of the person in custody, go and generate just a new power of attorney, someone who is possibly a better standing, who's able to be accessible and available. So they could generate a brand new document.
So they would simply just revoke that current POA with the individual who's incarcerated and choose another, ideally more suitable individual to act on their behalf.
That's
Okay,
correct.
rapid fire, Mike. This is a two-part question for you. So maybe you could touch on the, for lack of better words, the slippery slope when we choose to have joint bank accounts, as well as not giving away our PIN number to family members, and then maybe touch on some alternatives for older adults for in ways that their POA could actually access their money to pay bills, those sort of things. So some safeguard tips.
Yeah, so joint accounts are problematic because it grants equal access. Yes, as spouses and partners often entering into both joint accounts, it just makes easy access, and there's it's simpler for joint accounts. Problematic is that each has access to those assets. So a family member, let's call it of ill intent, will have full access to all the assets in those accounts. What do? We strongly suggest making sure on investments as well, having power of attorneys on those accounts. yes, they will have to enter into a bank or a investment firm power of attorney document, but it safeguards the assets or the funds within those accounts. There's some accountability if the power of attorney is involved in using any of those accounts. There's something new that's come throughout my work with the Ontario Securities Commission is trusted persons named along the way on financial investment accounts, possibly trusted persons in financial institutions. So when something is amiss, and we would love to see it, currently in my hat of frauds with the romance scams, the cryptocurrency investment facing older adults in the millions and millions of dollars, where when a transaction or withdrawal is happening, you're allowed to call a trusted person. It's that checks and balance. Trusted person is a different hat we're talking about here, but it helps us those checks and balances on those suspicious fraudulent matters. Going back to power of attorneys, the power of attorney on accounts is again another checks and balance and accountability to what's happening within that account. When it comes to PINs, sharing the PIN is very problematic because what the banks will do is we'll be in breach of the card agreement between the card holder and the bank. Therefore, any losses suffered buying alcohol, buying OLG products, gaming products, and then you come back and it could be into the thousands, not just the hundreds. It's thousands and thousands and thousands of dollars because you provided that PIN or you wrote it on the back of your card or you put it on that little piece of tape on the card, you'll be in breach of that agreement. So what do we do about that? We go back to always keep the PIN private and passwords private.
Wonderful. Next question. When the police put conditions to not act as their POA, is this temporary or permanent? And then second part is, at what point can the senior victim go to an alternative like the PGT to be their guardian or trustee?
So terms of bail. So upon the laying of the charge to the conclusion of the prosecution, conviction or not, there can be a variance of bail terms, so they can be not to be a power of attorney. We also would say that not to be a power of attorney for anyone else, depending on the circumstances of the investigation, can be very challenging if there's only one victim. But we certainly will remove them as ability to be power of attorney based on those bail conditions. We have seen on conviction and peace bond entries, peace bond resolutions, where they're not to act as a power of attorney for a period of time. It's not indefinite. It would be like a term of probation, a term of the order to say you can't act as a power of attorney for an extended period of time. Really, it's the ultimate timeout, right? It's the ultimate timeout, giving the older adult time and space and time and place to revisit their affairs after going through a very traumatic situation. So I answered that. What was the last section of that one, Laura? There was something else on that.
There was, but I have clicked the answer is answered, so it has disappeared on my end.
I'm
And
sorry about that.
apparently I have zero recall at this point. So we're going to move on to the next question because a couple people want.
I have it, Lori. Mary, you let
Okay.
me know. Great. Thanks, Mary. Good to see you. Um, Filing a complaint to the OPGT and when will they take
Yes.
over? You can file a
Yes.
complaint to the OPGT anytime. Anytime.
Yeah.
I do not have the answer, and it's not my expertise to say when they take over. I do know that their resources are thin. I do know that they can be overwhelmed in workloads in case management. And the Ontario government, from what I had in training a long time ago, does not want to be in the business of managing people's financial affairs. They will do everything they can to find alternative ways. So you can file a complaint to the investigations unit. There's an intake process. So it's more intake first, and then there's usually a resolution tree, and then they go into an investigation unit at any point of the process. But for them to take over, it's I don't have the details on that, but it's a challenge.
And everyone will notice in the chat box, my wonderful colleague Mary has put in the PGT's office investigation unit number. So if anyone wants to reach out and ask these type of questions directly to the PGT's office. So last question, and we're getting a couple questions in regards to exactly what is a peace bond?
So yeah, a peace bond is I wish Jason was here, he would give me a hand. So a peace bond is you have a charge before the court. Instead of a conviction, both sides, the Crown, the victim, so the Crown supported by the victim supported by the Crown in the police investigation, the defense, so the defense, the accused, um, resolve the matter by entering into the peace bond, a Section 810 order. It's a process ordered where there's a term of keeping the peace between one another. It's a tool of resolution instead of a conviction of two individuals coming to terms with let's keep the peace for a period of time. We may be able to put in some order saying not to be a power of attorney. Jason would be able to help me with that detail, but it's a resolution option for the Crown Attorney and the defense to come up with to resolve the complexity of a case where let's say we have the two family members. We're trying to seek resolution. We're not going to a full restorative justice, counseling outside of the court process. We're going to enter into a formal order, a peace bond to keep the peace. A breach of that peace or a breach of that order results in another criminal charge. So that helps. Yeah, that's a peace bond.
Great answer, Mike, for not being a Crown attorney. So thank you for that. And then just one last comment because I love our social work partners out there. A comment for your last slide to also add social workers in regards to their mandatory reporting and their professional obligations to their regulatory college. So
Thank you.
it was nice to be able to get to a lot of the questions that were coming in. I want to take the opportunity on behalf of Elder Abuse Prevention Ontario to thank you for your wonderful presentation. And I know in doing the consultation calls for our office, about 80% of our calls are financial abuse related, specifically that misuse of power of attorney. So very timely. We appreciate your expertise, Mike, and thank you so much.
Thank you, Laura, and thank you to the Elder Abuse Prevention Ontario team. This is a fabulous day, a fabulous symposium, and I look forward to seeing everyone again. Elder Abuse Prevention Ontario and all the networks. Remember, everybody, volunteer at your close network is important to all of us. So thank you so much.
Thanks, Mike. Okay, everyone. I'm happy to say that we are actually ahead of schedule. Ryan knows how I feel about time and time management. So this truly makes me happy that we're running about 15 minutes early. We're lucky to have our police partners here online, and we're going to dive into a great, relaxed panel, which is focusing on what happens after you call the police. So all of us know that when a report of elder abuse is made, it sets potentially a complex investigation or looking at supports that need to happen, that need to move. To help us navigate this journey, we are joined by three distinguished investigators who represent the front line of victim support as well as criminal accountability across our vast province of Ontario. So this afternoon, I'd like to first welcome Detective Staff Sergeant Kim Hogan. Kim is with OPP Victim Support Unit in the West Region. Kim has 24 years of experience. Detective Staff Sergeant Hogan is a provincial leader in victim-centered policing. She manages the Detachment Abuse Issues Investigator Program and is the key architect of specialized training within the OPP. Notably, in March of this year, she helped launch the OPP's first older adult abuse investigator course, ensuring that all officers across the province are equipped with the specific skills needed to handle these sensitive situations. So welcome, Kim. We're thrilled to have you here this afternoon. And then next, I am thrilled to introduce Detective Isabelle Woulette with Ottawa Police Services. She's within the Elder and Vulnerable Adults Investigation Unit. Detective Woulette brings over 30 years of policing expertise to our panel. For the past 8 years, she has focused exclusively on Elder and Vulnerable Adults Investigation Unit. She's tackled cases of physical, financial, as well as sexual abuse. She is absolutely a strong advocate for a collaborative community approach, working side by side with partners, community partners, to ensure that justice and the process remains always victim orientated and truly collaborative. Welcome, Isabel. And then last but absolutely not least is Detective Constable Kevin Middleton. Kevin is with the Thunder Bay Police Service within the Hate Crime and Elder Abuse Investigator. Detective Constable Middleton has spent 13 out of his 18 years in policing dedicated to supporting victims of intimate partner violence, hate crimes, as well as elder abuse. He was key in launching the Elder Abuse Prevention Committee for Thunder Bay. Kevin has had a formidable investigation track record, securing convictions for theft by holding power of attorney and manslaughter within long-term care. Most recently, he led a landmark investigation resulting in criminal negligence charges against a long-term care corporation, as well as one staff member. So please join me in welcoming our panel as they pull back the curtain on investigation process as well as policing practices. Welcome, everyone. Okay, welcome back, everyone. Happy that I was able to do all of the introductions pre-break. So let's just jump right into our police panel here.
Everybody can come online now.
Yeah.
Perfect. Excellent.
Welcome, Kim. You missed your wonderful introduction, so.
My apologies.
No, that's okay. That's okay. We're happy that you're here.
Okay, so I think we'll begin by just, I guess, first introducing, Laura's introduced everyone and your background, but people may not know specifically what your roles are within your detachment. So we know across the province, many police services have designated officers or units that respond and support to seniors in the community. So maybe we can begin by each of you describing what your role or units are at your own police forces. So maybe we'll start with Kevin.
Yeah, sure. Yeah, thanks for the invite. So the role as the elder abuse detective would oversee all elder abuse investigations. So whether it comes from uniform, they would complete their reports, and then the elder abuse detective would follow up and make sure everything was done completely. And if there's any follow-ups required, then he can follow up with those. And they're also there for the training purposes for other officers for advice.
Great. Isabel?
Yeah, I work at the Ottawa Police Service in the Elder and Vulnerable Adult Investigations Unit. We are a team of 2 investigators and 1 sergeant. We investigate crimes, financial, sexual, and physical, to the exception of domestic violence, so intimate partner violence. And yeah, that's what we do.
And Kim.
Thank you. I work for the Victim Response Support Unit. So I am the representative for West Region, and every region in the province has someone in my position. We oversee the abuse portfolio. So I work directly with our Regional Abuse Issues Coordinator in West Region. And we oversee the Detachment Abuse Issues Investigator Program. So every detachment in the province has a Detachment Abuse Issues Investigator in their detachment. We also work closely with the Academy to create courses for abuse issues, such as the Older Adults Investigator, Sexual Assault Investigator course, and Intimate Partner Violence.
Great. I also want to say that I think most of the police forces also do a lot of education and outreach in their communities. And some of you, I believe, do some of the education to seniors groups. And if not, there may be someone within your services that do that education to community senior groups or events, conferences, etc. So whether that's yourselves or is that other officers, is that correct for most people?
Yes.
Yeah,
we have a-
exactly. Yeah, if it wasn't for all the community partners we work with, we could get together and do presentations, education throughout the community, whether it's professional or to the public itself.
Great. And Isabel, or
Yeah, because we're such a small team, we have a community policing officers who will go into community and offer presentations on different various topics. An elder is one of those.
and Kim, I would suspect that will go down to each regional detachment across Ontario, that someone would reach out to their own local OPP detachment to find someone in that position.
Right. And we also have our anti-rackets unit, which does a lot of fraud investigations, and they have done a lot of work for seniors and have supports and do a lot of education.
Great, thank you. And I know that you're involved in many other committees, high risk assessment teams, and working with mental health teams and community partners. And I think that's important to sort of set that stage because, as we mentioned initially in our opening remarks, the collaboration with our community partners is so important because we know that often cases may not be criminal in nature, but the older adult may need some support, health, or community-based services to follow up if the case isn't sort of criminal in nature. So I know that it will come up in our discussion, but I think it's important for our attendees to recognize the vast roles that the police do play in responding to elder abuse. So I'm going to ask Laura to ask our next question.
Absolutely. Thank you, Ryan. So, what specific training is currently being provided to all levels of officers across Ontario, specifically on elder abuse? We'll go Kevin, Isabel, and Kim.
So all officers are now trained from the basic constable at the Ontario Police College. So everybody gets that now. And so any division within this service now requires, under new legislation, will require at least one person to have a higher training through maybe it's a police college, or there's a couple other agencies that will also offer that, but that's now mandatory. So we are just trying to catch up with that.
Mm-hmm. Isabel?
Yeah, same thing as Kevin. OPC, the Ontario Police College, offers the basic training to all the recruits, and then as Ottawa Police Service, there's no extra training being provided to our recruits or to any officers on the road. All of the files come directly to us after first response.
And Kim?
And for the OPP, we have they get the recruit training at the Ontario Police College, and we also have a 6-hour mandatory online learning for investigations involving older adults and vulnerable. We have our anti-fraud, anti-rackets unit also has created a handbook for our frontline officers to utilize that takes them step by step through the investigations, and we have a plugin in our reports to ensure that our officers are capturing the correct information that is required during their investigation. We've recently launched our Abuse of Older Adults Investigator course, was just accredited by the OPC, so it's equivalent to what their elder abuse course would be. So we have at least several members in each detachment identified as trained investigators. And our anti-fraud unit does lunch and learns and different training sessions on things like grandparent scams and trends that they're seeing.
That's great. Thank you.
And I just want to reiterate too the courses that the officers are speaking to around the Ontario Police College are full week courses. So it's not just a one day come and learn what you can. It's very intensive. Each day is full of content speakers, experts that come and educate the officers as well. And and which Kevin alluded to as well as the changes in the Police Act that was done just in the past few years, that now it is mandatory for the police to have that training. So that's a big step forward for us working in the field, to ensure that there is officers that have that specific training in regards to elder abuse investigation. So it's great to see this progress made, and working in the field for many years, it's nice to see the progress that's being made in terms of response. So
Yeah,
I'm just going to, so go ahead, Kevin.
I'd like to add, when you go to these courses for these specialized training, it's all about networking as well. So we reach out and we have contacts throughout. So if you're coming back to a smaller agency, you're not just there alone. You're there and you have contacts from all the other elder abuse detectives across the province, so which we do reach out to quite often. Yeah.
Yes. I think that sharing of knowledge and expertise is so imperative when you get, a specific case that you may need further, assistance on, or learnings from other officers as well. So thank you. So we're going to sort of walk kind of a step-by-step process through responses from police. So we start with maybe the contact or a wellness check. So we get people that are often asking us, or someone will say, well, just ask for a wellness check. So Isabel, can you clarify for us what is a check on the well-being, or what is often known as a wellness check?
Yeah, we do call them wellness checks here as well. Essentially, you will have, it could be just anybody calling us, or attending a station detachment, or making a complaint online. However, they choose to reach out to police. And if they have any concern that may warrant us to go check on that person, we will deploy and go and check if the person is doing okay. And so we do that on the regular basis.
Great. And Kevin, do police automatically do a check on the well-being if they receive a call from a third party? So maybe someone's concerned about their neighbor who might be neglected. They see different things happening maybe around the home, or nobody showing up at the home. Does that automatically, do people have to use that term check on the well-being, or how does that process work within police?
No, you don't have to normally use well-being, check well-being. You just have concerns. You want to check on somebody or are not able to reach them by phone, and they normally meet us at coffee, and it hasn't been there for the last couple of days. Any type of details like that would be valuable for the officers, and then it would be just triaged. And for whenever the officers are available, then they can go check on them.
And I would assume that would be a frontline officer in full uniform, or can people, if they know the situation, maybe, the perpetrator might be home, or there may be that fear of authority. Is there a way that officers or detectives often that are in plain clothes could also show up, or is it always maybe the first line of response is the frontline officer?
For the Ottawa Police, the response is based often on how the call comes in. So if the person went online to make a report, it will then skip the frontline officers and come to our office. If they call a dispatcher directly, it's more of an immediate response. Then officers may show up. We also have Crime Stoppers if they want to remain anonymous and they just want us to check on the well-being, make sure that they're okay, but stay out of involving themselves. Then they can do that as well. So the response and who shows up really depends on how the complaint was brought in.
I think it's important for the caller to articulate what their concern is. If there is that fear that the suspect is home at the time, then that would be addressed prior to an officer attending, for sure.
Oh, that's a good note, actually. And maybe say with a safe time to maybe come to do that visit or the check on the well-being, knowing when that, maybe say the potential or alleged abuser or perpetrator may not be home. So then they have that opportunity to have that dialogue. So
as much information as they can provide to be valuable. Saying if it is that's serious, then they can ask for, like for Thunder Bay, you can ask for plain clothes. So as the elder abuse detective, they can go there in plain clothes, or call and make arrangements, or find out when the perpetrator may not be home. Or like I've gone there before, and it turns out the perpetrator was there, and I've just pretended I was selling cell phone plans at the time. But then I've followed up another time when they weren't there. So all depends.
So feeling out the circumstances. Laura?
Yeah, so moving on, Kevin, maybe you could discuss some reporting options if there's been an incident. From my experience, especially if I'm talking to a concerned family member or a senior, they think the only way to get a hold of police is 911. So maybe you could go through the handful of options individuals have.
Yeah, no problem. Well, in Thunder Bay in particular, we have an online portal where you can place elder abuse concerns into a report, and that'll get forwarded to either detachment uniform if it's more severe, or you can go to the elder abuse detective for a follow-up down the road. There's also calling the front desk to make a report, as well as if it's more severe, 911. And I should be mentioned, don't be get caught up on 911 or just front desk. If it's severe, the front desk will send it up to 911 right away, and vice versa. It's happened before.
So many times when somebody's thinking about reporting to police, they're not too sure what information to give because the families I've worked with, there's a lot going on. There's family dynamics. There could be history of abuse and violence. So I can spend an hour on the phone with an individual. However, you guys can't. So what important information does a person need to give to police to do that follow up? Kevin, do you want to take this one too?
Yeah. So again, it's any observations that they've seen themselves, and if they have any facts that we can use, or witnesses that we can follow up, or some concerns that may fit the criteria for a criminal investigation. If not, even if there's no services coming in, or they're being turned down by the power of attorney, or little types of things like that, or haven't seen the person in a while, or sudden loss of weight, not allowed to see their bank statements anymore, whatever they fear that they, even if it's not facts that they believe that they've heard this, it doesn't matter. We're just still going to go check the welfare, and then we can follow up with that person alone and speak to them and see.
Excellent, Kevin. Yeah, it's always really intimidating. The individuals that I speak to, they feel very overwhelmed and intimidated thinking about involving police. So, Isabel, if you could take this question. So let's say now somebody's made the report, they know exactly how to articulate what's going on in that home. Once police are on scene, how do they ensure they speak to that older adult privately? We know how important that is. So ideally, then that officer has a better idea of how to assess the situation, especially if the senior is being controlled by that caregiver or spouse. Maybe you can talk about some techniques that officers use to ensure that they have that private conversation.
Yeah, I would say that this is a case by case scenario, depending on you attend a home, depending on the size of the home. I mean, personally, like this is frontline based at this point because, patrol officers, let's say, attend in this circumstance that you're talking about. You can't really speak freely when the perpetrator is downstairs and you're upstairs. It may sound or be like a private, but it's really not comfortable. And if that's the case, there's so many alternatives that can occur. We can get some information on scene, and then the file will be eventually, routed to the right unit, which would be my unit. And then I would then make arrangements. I mean, I've taken people to Tim Hortons before. They've come to the police stations, wherever they're comfortable. Sometimes they feel that the police station may be a little bit dramatic. We improvise. And we try to find a common ground in a place where the person would be comfortable, but being free and to speak in an environment that's not stressful is key.
Yeah, I really think you hit the nail on the head, Isabel, with the reality that elder abuse is always in the gray area of society. So I think whether you're police or a service provider, we really need to get creative. There's not just one carbon copy solution to these typically really complex issues. So Kim, I'm going to throw you the next question. Anytime I do a training or I speak to an older adult or sorry, a service provider and they tell me a complex story of what's going on, I always tell or ask the individual or tell people in training, I'm always going to ask, what does the senior want? So maybe you can talk about certain protocols when a competent and capable older adult discloses abuse to a service provider or family member, but they clearly don't want to move forward with even thinking about laying charges. They just want the abuse to stop. They don't want their, typically adult son to be charged. So maybe you could talk about that, Kim.
Well, every adult has the right to make their own decision, as with anyone else. If they do not, as long as it's not a situation of intimate partner violence, if an adult doesn't want to proceed with somebody, we certainly aren't going to force them into a process that they don't want. What we will do is engage supports for that person, be it our mental health crisis nurses that respond with our officers. We have our detachment abuse issues investigators. In certain areas, we have victim specialists that could engage with the person and provide support. We would also involve victim services and discuss with the adults other options that could be potentially be available for them and supports.
Excellent. And I always remind individuals when I'm training professionals is just like, everyone on screen today, I have the right to make bad decisions all day long. And I'm not going to have a team of officers and social workers knocking at my door. And for a competent, capable senior, that story is exactly the same. Isabella, Kevin, is there anything you wanted to add to Kim's discussion here?
Only that I completely agree with Kim, but if there is a doubt of capacity, if like a person cannot, if the person cannot appreciate the risk that they are making and decided not to charge and continue to live at risk, if they don't have the capacity to understand those risks, then the choice of not laying charges does not necessarily belong to them anymore, because there is a protective aspect of public safety here that we need to address if the person does not have capacity to make those decisions.
Yeah, thanks, Isabel, because the question did come in about, do the police screen for capacity? Or are they just sort of, are they allowed to just comment on the apparent capacity of the person and just take the report and report those facts?
No,
like, is there
we would
Go ahead.
report observations that we see, but we're not professionals. We can't assess people. If there's a recent assessment, yeah, we could use that, or we can ask for assessment. I wanted to go back to Kim made a good point there. Where a lot of times we go to a senior and they're normally not the ones reporting to police because they don't ever ask police for help. So you go talk to a senior and you go, in my experience, they're so thankful that you're there when they find out, well, it doesn't necessarily have to be charges, that we're just there trying to stop the abuse. And if the person can resign as power of attorney, or the finance abuse can stop, or whatever it is, that they're just thankful. And if there's any concerns down the road, then the senior will reach out to the police at that time.
Yeah, it certainly would depend on the circumstances of the call and their abilities. And we do train in our older adults abuse investigators course. Certain questions to ask to get a gauge on the person's capacity. But like Kevin said, like, we're certainly not medical trained in doing that. It might be a case if they're in a long-term care facility, we may ask to consult with somebody to see what if they've had any testing done and what their ability is or what their status is there.
But just to be clear, and this is in my jurisdiction, I do not require a capacity assessment to lay my charges. If I feel that if my common sense is indicating to me that the person is not understanding the risk, I will gather information. I will conduct an investigation, but a capacity assessment is not necessary for me to lay charges if I feel they are warranted.
Excellent, Isabel. And I'm going to throw this next question to you too as well. Maybe you could touch on when it is mandatory for somebody to report elder abuse. There's very clear legislation for mandatory reporting versus community. So maybe you could touch on that for all of us.
Okay, so yes, I can. the Good Samaritan law is what it is, right? It's not an imposition on anybody to do the right thing. So I'll just say that. And no one has to really report anything unless they are in a role that positions them to act in that way. For example, if you are a personal support worker working in an LTC, working in a retirement home, or working in a community-based service provider, you will have, signed a contract, you will have employment rules and conditions and policies that dictate that you have to report any abuse that you observe. And so oftentimes in that field, it will occur that way. And this is how the complaints will trickle in to us, because they are mandated through their policies, internal policies of their employers to report. So,
and to be clear, also the legislation, as spoken to this morning by Curtis, under the Retirement Home Act, it was mandatory reporting, as you just said, Isabel, in long-term care and retirement homes. So there is laws and legislation in place, and for the mandatory reporting. The only person that does not have to report in those homes are the residents themselves, but anybody can report, as we talked about, and in Ministry of Long-Term Care, you can report by phone or by email, etc. And we'll post that in our chat box as well. So I think that reporting is sometimes people, is it anonymous, not anonymous? We've talked about Crime Stoppers, the anonymous way if somebody is concerned. So there are options there if people do not want to just sort of disclose that information to the police or other authorities.
And just to highlight, go ahead, Kevin.
I'd say in Thunder Bay, if you're reporting, if you're calling into the police station yourself, you can ask to remain anonymous, but provide your number for the officer to follow up if he or she has any more further follow-up questions. Otherwise, Crime Stoppers is a fabulous tool too.
And to highlight around the mandatory reporting within long-term care and retirement homes, it's not just an individual that is currently being abused, it's that individual that's at risk of suffering abuse, that the individual shall make that report to RHRA or long-term care action line. So now moving on, I want all of you to be able to answer these questions, this next question, because it looks different depending if we're in Thunder Bay versus Ottawa versus OPP land. So maybe each one of you, starting with Kim and then moving to Isabel, to Kevin, talk about the follow-up process after an individual calls the police and that report is filed or they've made a statement. Maybe you could touch on what that looks like for OPP.
Again, it certainly depends on what the nature of the call is. So when somebody contacts the police, typically a frontline officer is going to be the responding officer. Depending on whether it's financial or it's physical, what the nature of the offense is, it will then potentially move into a major crime unit member to investigate that. The role of the detachment abuse issues investigators review all abuse occurrences. So automatically the abuse issues investigator would review the investigation to ensure everything was there and that the proper supports were provided at the time. Then if it's moving into a major crime, a detective will reach out and schedule a time for interviews and follow-up investigation.
Excellent. And how about you, Isabel?
So there's several ways to report to the Ottawa Police. You can do it anonymously through Crime Stoppers. You can do it by contacting our dispatch office, communication center, depending on the call, which might, launch a automatic first responder response where officers will go to your home. If it's less urgent or a matter that is not sensitive, it can be done online. Or on the phone. Now, depending on which way you decide to report to us, will dictate the response automatically. But no matter what, if there's a follow-up to be done, and it is in the parameters of the mandate of my unit, it will come to me via a routing system that identifies it as being mandated by my unit to investigate. And from there, I take over the report, the investigation, and conduct the follow-ups to come to an outcome, whether it's laying charges or using other alternative methods of dealing with it, or just providing support.
Thank you,
Yeah, so
Isabel. Kevin, go ahead.
in Thunder Bay, we're very similar to everybody else in that aspect. It depends on what the call is. If it's just to check the well-being, and they can ask for a follow-up on what the results were. But again, it's up to the person we go do the check the well-being. If they want nothing said to them and private information, then we'll just have to tell them sorry. It's they're okay, but that we can't tell you any more information. For the uniform, if they have a follow-up, then they can investigate themselves. But some of these calls regarding elder abuse have been long time occurring. So the investigation is a very complicated one, which would be forwarded to the elder abuse division or the fraud division, who would follow up with the involved parties as well as the witnesses. And after that, then whether it goes to charges or we forward it to social agencies, community agencies, capacity assessors, or doctors. We work with everybody.
Wonderful. And I think Rayanne has our next question.
Yeah, just I want to follow up on the reporting piece. So somebody had put in the chat box that those in long-term care, if a person does see neglect or there's abuse happening in the long-term care and they report it, they themselves, if they're incapable, are not able to either advocate on themselves or make that report. And how do we, and I know, Kevin, you've done, probably all of you have, but I know, Kevin, you've done some recent investigations in long-term care itself. So just letting people know, what steps does a person, what are the steps from a police investigation when it is a long-term care home? I would assume that investigation is a little bit different than a community-based investigation when know that maybe it's a personal support worker who may be causing the abuse, or other family members. So maybe could you just walk through that a little bit so people could understand what the options are and what the police response is in those situations, because it can be very complex.
Okay, so under Long-Term Care Home Act, their duty is to report it to the Ministry of Long-Term Care as well as police within 24 hours if there is any suspicion of neglect or abuse. And that'll go for Thunder Bay, it goes to the elder abuse detective, and he or she will review it and decide if there's required follow-up on time. Sometimes I'll send an email back requesting names of witnesses, or just for a request to follow up on what their investigation results were, and as well as contact to the family members as well as the victim. If their capacity is still with it, we can go speak with them as well, and then we record all that.
So then you'd have access to go and talk to witnesses probably in the long-term care home who may have seen something happening. So you would do.
Yeah, and they get good video in the hallways and the common rooms there, as well as the family to see. And if with us keeping a record of that, we have a history to see if there's been any other involvement with the personal care worker or nurse, or could be a resident in long-term care that's causing some trouble, right? So we'll see if there's any issues, and then we work with the home to prevent this from happening again. And if there's anything more serious in nature, criminal, then charges could result. Yeah.
And do the police, for anyone, do the police also do investigation in parallel with the Ministry of Long-Term Care?
Sometimes. Sometimes we will, but I have to say we have different mandates. And so, we certainly may talk to each other to get some information, but in my situation, it's very rare because we attend to different mandates.
Okay, thank you.
Yeah, ours would be our criminal investigation that we would be doing involving the particular involved persons. So our detectives would be attending the long-term care facility and speaking to witnesses, canvassing, obtaining any video evidence there might be, and doing their investigation from there.
Okay, great, thank you. There was another a question about where you're talking about Crime Stoppers too. Is Crime Stoppers a third-party organization? And if they are, do they own or collect that data that they receive? Or how does that system work?
Yeah, it's a very good question. There's Supreme Court ruling showing that police cannot have access to, or anybody get access to who's reporting to Crime Stoppers. So you're definitely anonymous, and we can never get that information. Although sometimes it's hard to follow up if we have more questions, but it is what it is. It's there for a purpose.
And Kevin, I think you just highlighted something really important. I always remind people when I'm talking to them, if I'm on a call with them, and I'm suggesting that they call potentially a non-emergency line to make a statement or make a report. But I do always say that it's an option to remain anonymous. But if you actually want that follow-up from the attending officer, that I always encourage to give their name and number so they can get that follow up and maybe do some more advocacy on behalf of that vulnerable senior. So really good point, Kevin.
And I know that because we have OPP and we have regional police, so how do people know which like which police force to report to if they're a possible victim? So where I live, I have both. I have OPP and we have regional police, but in my area that I live in, I know that I fall into the OPP detachment area. So is that, Kim, maybe you can just give that information to people, because I'm in a lot of smaller communities, there are both. So if you can maybe touch on that.
Sure. Yeah, when you contact the police, usually you're directed to, if you call 911, you're directed to the police that you're in the jurisdiction that you're calling from. But we quite often get calls, even for offenses that have happened elsewhere, that a family member's calling in from somewhere else for. And we work together with the other agencies involved. So if the offense location was, say, in Thunder Bay, but the victim or a family member resided in OPP jurisdiction here, we would work together with Kevin to obtain any statements that he would like from us to assist him in the investigation.
Mm-hmm. And it's always where the crime has occurred, because I've had people that have called where they live, but their mom lives 2 hours away. So being mindful that if you're calling for that check on the welfare, if the crime or the incident, whatever you're concerned about, is in Wawa, you call those police. Even though you may live 3 hours away, you don't call your local police detachment. They will quickly tell you to call where the senior resides. So just a word of caution. So moving on, maybe each one of you could touch on your first thoughts when we're talking about the biggest barriers. We know that older adults face so many more and different barriers in reporting that they're being abused when we look at younger victims of crime. So could each one of you touch on just a couple barriers that you see that are really glaring, why older adults don't reach out for support? Kevin, I'll let you take the lead on this one.
Yeah, it's probably the most common is seniors not wanting to get. There's normally a family member that's taking advantage of them and abusing them, or whether it's financially or neglect. The senior doesn't want to lose contact with their family member, and that's the huge part. So my big job was to make sure they understand I'm not here to arrest their family member or their support that's or their neighbor that's been supporting them, that just want the abuse to stop, and then we can work with them with that. So there's lots available, and this usually works that way, and they're very happy at the end. But they don't understand that the way. Once police are involved, they figure someone's going to jail. It doesn't happen like that.
Everyone around just watches too much TV. That's typically, it's not wrapped up in 30 minutes and people aren't going to be thrown in jail. From my experience, especially working with women that are older and have been victimized for many, many years, there's usually a lot of shame and guilt. If it's a son, it's how could I raise somebody to do something like this to me? Kim, could you maybe build on some of the other barriers from your experience?
Yeah, I would say exactly what both of you have said. The isolation and guilt, the fear of losing that support. Sometimes that might be their only support person. And also, I would say sometimes a barrier for us would be a cognitive decline, being either like a memory loss and other cognitive declines.
And Isabel.
Yeah, I mean, there's potentially also shame not wanting to attract, visual on what's going on internally in the family. But also sometimes it's not knowing how, and that's why prevention is important. Just not knowing how, what to do, who to trust, who to tell.
Absolutely. I've worked with older adults that live in a city center and they didn't know that there was beneficial, meaningful resources just 2 blocks away from them. So being isolated has nothing to do with where we physically live. I've worked with rural and remote older adults that are very well connected, and then on the other side of the spectrum, city seniors that are much more isolated and don't know where to turn is a real barrier for older adults. So, next question is, how do police generally, I know it's always very case specific, work with either banks or financial institutions in an investigation of potentially financial exploitation? Go ahead, Kevin.
Sure. So it's case by case
Yeah.
specific. If it's an initial call, I'm going to go speak to the neighbor. There's an allegation, but no proof of some financial gains by either a family member or a power of attorney. I would go speak to that senior and it's like, this is where the allegations are. And if I can get a feel for it and see how things are going, if they want to show me their bank statements, that'd be great. They can even sign a consent where I just look back the last couple of months. And if they're adamant no, well, then there's some more concerns there. I can go talk to the bank, or as anybody, a member of the public can go talk to the bank and give them their concerns of elder abuse. And they're mandated to investigate themselves. And if they follow up and see some concerns, they will contact police. But if there's more concerns I see, then we'll just write production orders for their bank statements to get the results and see who is taking advantage of them.
Absolutely. So,
One of the-
Isabel,
Yes.
what if you were to talk to a family member, let's say before, because we're all about ideally preventing abuse before it even happens. That's, what we would all want and if the world was perfect. So, would you have any advice to a family or concerned friend of a senior of how to prevent financial abuse before it even starts? Is there sort of some safeguarding tips seniors could employ?
Yeah, I think, making and go back to what Mike said earlier, having your affairs in order, having proper documentation that will protect you, such as a power of attorney, that gives a little bit more, as opposed to, having joint accounts, which gives you an extra protection because really the spending has to be in the benefit of the account holder. And so this is one protection that can be added, but also sometimes it's a matter of understanding the limits and the capacity of the person using the banking system. So, for example, we can, let's say the person, the older adult has access, or even the vulnerable adult for that matter, has access to a debit card. Well, maybe we take the tap away, maybe we take the ATM away, and maybe we just do transactions that are within the financial institution. And at that point, usually they get to know their clients and the branch, or there's still that relationship, that exists where, okay, I know Mrs. Simpson, that's removing, all the layers of potential, you know, mishap that can occur, right? Is where you have to, and then people will say, well, but what if she cannot go to the bank? Where she can't get to the bank? Well, at that point, then maybe why do we even have a debit card then if we can't necessarily, go anywhere? So I think it's baby steps and just really adjusting. I would also say that, the banks have systems in place to protect the elderly, and so we can have red flags put on the ticket, on the accounts. We can have notes put on there to ensure that, whoever is going to the bank must be the owner of the card, must be perhaps this is a POA, this is no other persons. So we can put notes, as many as we want, to let the staff know at the bank that, there's caution to be had with this particular client. So communication really with the organization is key.
Yeah, it's all about collaborating and all of us getting out
Yes.
of our tunnel vision, right? And our silos that we
And
tend
it's
to work
really
in.
quite simple, right?
Yeah.
It's just to, yeah. And the situations are always fluid, and that's why it's important to have constant communication, because capacity and decline occurs on a fluid basis, you know? So, yeah.
Is there anything, Kevin or Kim, you wanted to add to Isabella's answer?
Yeah, I would add, I know we've had situations where they've actually, certain banks have like a trust person. So if there is a lot of activity or frequent withdrawals or large sum withdrawals, the daughter or the power attorney can be added, so the bank can also notify that person of that. And I would really have a conversation around phone calls and discussing, no one is ever going to call you and ask for money over the phone or cryptocurrency. Having those discussions, a police officer is never going to come to your home and ask for money. So those are all red flags, and having that open line of communication so that they're confident in knowing that is extremely important.
Yeah, really good point, Kim, is, it's what all of our mothers taught us when we were young is when it comes to frauds, if it sounds too good to be true, it probably is. So, the king of Dubai is probably not reaching out to any one of us ladies this afternoon, or you, Kevin, as well. Kevin, is there anything you wanted to add to this conversation?
Yeah, they made a lot of good points. I just
Yeah.
wanted to add, a lot of times we get to a situation where their finances aren't in order. They have no power of attorney. They have no trusted person on their account. So a lot of times we just forward it to the bank or to get some resources and get that all in order. So it makes life a lot easier for them, for police, for banks, if there is a power of attorney, and then there's a lot more we can do if that's in order. If it's a shared account, it's so difficult for us. I remember just maybe one time I was able to charge someone who was on shared account who emptied the account, but it was a long investigation. I was able to prove that there was never any other types of transactions like that allowed before. It was not confident. So, but that was very difficult, very, very rare. That's when you hear that's a civil case.
Yeah. I would love to hear that story sometime, Kevin, because I've never heard of anyone successfully charging with that joint account setup. So I want to pull something out of our question and answer box, and I think the answers are going to highlight how different the responses to elder abuse and vulnerable seniors are across the province. So somebody in the chat box put in that in York Region, we know that they have the senior safety team, which is a great resource for those that live in York Region. Is there something like this available across Ontario at police detachments? Kim, maybe you could touch on this first.
It's difficult. Every area of the province is different, and resources are different everywhere. Honestly, your website actually has a phenomenal program in it where you can type in what resource you're looking for, what area you're in, and it will give you within kilometer radiuses of what you're looking for. So it's difficult for me to speak to what everywhere has, because everywhere has different resources in different communities.
Absolutely. And so I encourage, and my colleague Mary will put in the chat box, check out our website if you're interested in knowing if you're in more of a municipal area, there may be a specialized unit. And Kevin, maybe you could talk about what's going on in Thunder Bay and how people can reach out to your specific unit.
Yeah, in Thunder Bay District, we have created like a booklet that we hand out to the public, and it's available at the front desk. It's available at the library and 55 plus. And of course, it's got your guys' website in the back, but it's got all a bunch of local agencies that are offered, as well as what elder abuse is and how to prevent it and how to assist. I would say it's also not just for seniors, but it's also for family members, neighbors, friends, because a lot of the times we go to these calls where family members are wishing they were more involved with their mother, grandmothers, or fathers, and it's all hearsay of what I could have done. But if you were involved, if you were a power of attorney, you could have been monitoring the bank of your vulnerable parents and seen some scary transactions, and maybe they're involved with a scam that's been ongoing for the last couple of years that could have been stopped. So just instead of you don't have to be wishing I was more involved, but now you can say, okay, prevention is key.
I just want to
Absolutely.
also just remind people that Jason in his presentation mentioned LEAPS, which is the Law Enforcement Agencies and Partners Protecting Seniors. So that is a committee that all of us here sit on, except for Laura, I represent our organization. So there's police forces from across Ontario, as well as some provincial organization that support older adults. So that would also include the OPGT, the Ministry of Long-Term Care. We meet on a monthly basis and have education on different issues and topics that are relevant or trends. So over 130 people, I believe, officers and partners sit on that committee and are very active in their role. So across Ontario, there are teams, and that's why I say at the very beginning, there are the attachments, the positions are called different things. So it's kind of hard to track, who to ask for sometimes. So even just asking, do you have a dedicated officer that addresses seniors issues? Might be this the way to start a conversation when you're calling the police force, because there may be someone in their community outreach. Go the CEO was the actual definition in the policing. Their community officers that have that role. So it's important just to sort of ask who you could reach out to. So I think that's also helpful for people to know. Those officers are also, when we're talking about training, are hosting a conference in early June, a few weeks away, where we are bringing experts together to talk about some of these trends that we're talking about today, so they can improve their response and that collaboration with our partners to respond to the safety and security needs of seniors in the future.
And I do want to highlight that Lee's in the chat box just announced that there is 203 members on the LEAPS committee currently. So it is a growing committee.
Thank you. Please
Yeah,
isn't
so
to
if
grow membership.
you're with a small service and you're not involved with LEAPS, then you need to get involved, even if you don't have a elder abuse division. It's just for the outreach and for the contacts for the banks, all the other officers involved in Ontario. It's invaluable.
I just want to bring us back because I don't think we asked the question about the vulnerable person registry.
But Kim wanted to say something, so let's let Kim talk.
Sorry. I just wanted to add that every detachment abuse issues investigator has a list of their local supports. So like you said, everywhere has different names for different positions, but for the OPP areas, if you contact the detachment abuse issues investigator, they will have a list of resources available within that community.
I think it also goes back to our community partners to, if you have a service that you've expanded your service to meet the unique needs around elder abuse or other areas of vulnerability, to let the police know that you're there, that you have those services available, because they may not know until, if they have to do a deep dive. So letting them know that you're available, what services that you have. So if a situation comes up, they can directly reach out to you as well. So it kind of that collaboration goes both ways, I think, and they're more than happy to learn about those different services, because we know so many wait lists, and having access to services is so important.
Ryan, could you talk about how questions are coming in? How do people get on to LEAPS, the committee?
So if you're an officer, then you can send me an email, and it goes through our executive to for membership, and we also Lee's is part of that membership committee. So we can send you can send me an email and I can send it to the chairperson. Again,
put your email in the chat box.
It is for officers and provincial organizations, so it's not like a general committee, like public wide kind of a committee. There was a question about vulnerability, though, I do want to get back to. So there's a lot of times we see repeated calls to police that they're maybe concerned about the vulnerability of a person, and then maybe the police call and they don't know the background of that individual. Perhaps they may have some cognitive impairment or mental health that is on that they've been dealing with maybe for some time. Can someone maybe on the panel here talk about what is the vulnerable person registry, and is that helpful for families or even the individual themselves with the vulnerability to get signed up, and how do they go about doing that? Who wants to take that?
I actually don't have information on the vulnerable persons registry.
No.
Within your own police force?
No, yeah.
Okay, Kevin?
No, I'm not aware of that either.
We have different projects. We have one called Project Lifesaver that we have available. You're looking for information on how to get registered for that program?
Yeah, sure. Just letting people know what options are also available through policing. So Lifesaver is a a great example.
Yeah. So to be quite honest with you, I'll have to get back to you, Rianne, with information specifically how to register for that program. I would suggest contacting your local detachment. It's the local officers that work in that area that are trained and will be responding. So my recommendation would be to contact that detachment or the area that you're in to register for that.
So just for those who may not be familiar with that, so the Lifesaver program is for people who may have some cognitive impairments or wandering, where they would get registered. So if they do leave the home or residence and no one can find them, it's kind of a system where they can locate the individual, whether wear a bracelet or pendant, depending on that. That's the gist of that program. The vulnerable person registry is many police forces have it on their websites where you can put in personal information about a person that you might be concerned of that might get contacted the police. Maybe the person maybe have a let's say if the person's had a stroke and it may not be very verbal. If the police get in contact, they may make assumptions about what's wrong with that person. There's a capacity issue, so they're able to run that person in their system. Then they would have that information ahead of time, knowing what the circumstances are for that individual. If you want to add to that, Laura, because I know that you guys said.
I'm just keeping my eye on the chat box, and a couple people are chiming in. I think Kim's advice is the best advice is go to your local detachment because it looks like a lot of regional police, so Halton, City of Kawartha Lakes Police, have vulnerable registries. And it looks like you can also register online. So I would call your detachment or go to their website, see if you can just simply register a vulnerable individual. Toronto Police also has it. And then the Alzheimer's Society also has the Lifesaver project, depending, again, sort of like with police, depending which society is your local Alzheimer's Society. You can always call us and we can direct you as far as your next steps.
Yeah, so every city is different. Like
Yeah.
in Thunder Bay, we used to have the wandering persons registry. Now we don't have that, but you would still call the police front desk and you just put a police information report, add the names, contacts, possible locations where they may wander to, and that's how, and then we can put cautions on them.
Yeah. Perfect.
Great. Well, this has been really a great conversation. Hopefully people have been learning about processes and reporting as we go. We have one last question we're going to ask everyone. Perhaps you can share an example of an elder abuse case that resulted in a successful outcome. So whether that's charges that are being laid, or maybe your collaboration with a community partner or a new approach, whatever that might look like for yourself. So maybe we can start with Kim.
Sure. I have more of a project that I can speak to. So we had a grandparent scan project that we worked together with York Regional Police, Halton, Durham Regional Police, Toronto Police, Peel Regional Police, Hamilton, Ottawa, several Quebec Police Services, as well as FinTract and the Canadian Anti-Fraud Center. So it was a 3-month project. In total, there was 126 victims. They ranged in age from 46 to 95, and there was a total of $739,000 defrauded from people. So after the investigative process was completed, they actually arrested 15 people and charged 15 people with that. So that is a good example of a project that we've worked together with our other agencies to do.
That's great. That's excellent collaboration.
Yeah, that's great.
And it takes, and I know how long it takes to collaborate the people and especially so many different partners. So that's great to hear. Isabel?
Yeah, I recently had a case involving a lady who was living alone and she had dementia and it was progressing and she had a daughter who was charged for and but I'll leave that aside because the example I want to give is not about charges, but it's about the collaborative effort that led to her being safe. And essentially, neighbors started noticing, and then neighbors started getting involved to help her. But really, at the end of the day, it's, they realized they needed help. And so that from there, eventually police was contacted, and then we introduced, Ontario Health at Home to have services inside the home. And then the home wasn't safe. So we had community paramedics, watching over her on a regular basis. But again, it was, realizing that this person is declining, and how do we get this, because she's no longer really able to cope. But as we all know, getting a person, taking somebody's liberties away, saying you can no longer live in your home is a big deal. And we don't just do that by snapping your fingers. There's processes in place to protect, those people from, losing their liberties. But essentially, paramedics were looking after her. The home wasn't safe. We had the community firefighters come in to look into that. And then I had made a report also to the public guardian trustee, because this person had no allies working with her. Her neighbor was taking her to the bank, but she was a huge target for anybody to just come in and just, defraud her financially or take over her home and just live there, because, like I said, there was a daughter in the background with a bad entourage. But there was, a few trips to the hospital that unfortunately did not lead to her being found to be incapable. So that, we all came back. She went back to her house, and we kept pushing and pushing for the services. But eventually, the culmination of all the services really led to this person finally being assessed, because all of the partners were, okay, this person now has reached a certain level in her diagnosis that is now, dangerous, and we need to really. And OPGT took the file over. The house was sold. She was placed in care in an LTC. And I think that had there been no eyes on this person, she would have been alone home in a dangerous situation, and maybe nobody would really, know. So what happened to her, or she would have been really, could have been starving, could have been just exposed to so many possibilities that are not good. So I just think that that was a great example of teamwork, between the OPGT, Ontario Health at Home, police, paramedics, fire, and Good Samaritans.
That's great to
It
hear.
does take a village sometimes.
Yes, and that breakdown of, that we can share across sectors around information when we know there's that vulnerability. We just did a conference a month ago or 2 months ago, I guess, with a privacy commissioner, is talking about that sharing of information when there's someone at risk. So if anybody's interested, you can go back to our website and find more information about that sharing.
I'm not going to talk about this, but I will say, just, and this is for another time and another conversation, although in this case, we're able to work together. Earlier, Laura had touched on what was a hurdle that we faced. And sadly, I do have to say that the hurdle of privacy between organization is something sometimes that prevents or good investigations from occurring or offer great delay. But hopefully we get to speak with, on that another time, because it is becoming a problem.
Yeah, I would encourage people to go back and watch that video from the past conference in this past March with the Information and Privacy Commissioner of Ontario, because it was very informative. So, and last but not least, Kevin.
I got a successful case. I guess I don't know how much time you have. I could bring up one where it was actually check the welfare case. A brother was calling up the Thunder Bay Police. He lives down in the GTA area, and I wanted to check on his sister, as she usually calls on her birthday every year and hasn't called and on holidays. Okay, so it actually took a couple of check the welfares, and then him calling us and seeing, is there anybody else? Is there an elder abuse detective? So I end up speaking to him, gives me a background, as much information that I could get, and then I went and checked the welfare with the assistance. We were using public guardian trustee, a capacity assessor, other police services for witness testimony, um, paramedics. It all resulted in, so it turns out the woman was originally living down in Toronto area, and her husband passed away, and the neighbor had been taking care of her, and fabulous neighbor, but she ended up having to move, and she came back on the weekends to check on her, and her capacity was diminishing, so she found out that she had a daughter up in Thunder Bay, and reached out to the daughter, can you please help your mom to get some admission to long-term care down here? And it turns out the daughter came down to Toronto, moved her back up to Thunder Bay, took her to a lawyer in a week and became power of attorney and executor to her will, and ended up emptying her bank account and placed the mom in a basement of her house. And then by the time we went did the welfare check, and that's when we found out, okay, she did not have access to food. We used her medical records, lost a ton of weight. So we were able to get her to the hospital. She was like dying by the time we saw her. And the story I tell you is because she's bounced back so much. She is living a wonderful life down back in the Toronto area and making lots of friends, long-term care. And she's so thankful. And the daughter and the husband was charged and convicted, failed to provide necessities of life, forcible confinement, brought over, theft by power of attorney, and the judge said it was his last case before he retired. He says the worst case he's ever heard, and so they got 2 years less a day, and the husband got 2 years plus a day. So yeah, but now I still keep in contact with the senior and her brother living down in Toronto, and so there are. But most cases aren't charges, I should say. Most cases we get their finances in order, and they don't have protection. So now they do. So, and the seniors are usually happy with that, but it could go either way.
Yeah, and I guess success based on the individuals, what they perceive as that success for them too, right? So
that's what I always tell the seniors: we're putting you back in charge of your life. Is what is it you want? I know a lot of other family members are very upset with your decisions, but it's your right to make bad decisions or good decisions. But whatever you feel, because you're the one who wants still contact with your family members, and that's what it comes down to, right? And I should say, the senior who's living down in Toronto has requested the courts to have permission to speak. Now she's developed a relationship with her daughter now. So, and the daughter's very apologetic. So, and getting the help that she required.
Well, that's a good story to end on. And I want to thank everyone here for their passion and commitment to working with seniors. And I think it does take that special compassion and ability to want to work with older adults, continue with the helping our seniors in our communities, because there's some people who choose to work in other sectors, which is great. But it's so nice to hear, and I can see it and hear it, and I know I've seen all of you working over the years in your field. So I want to thank you for sharing your expertise and your stories and your wisdom with us and our learnings, and for our attendees who have stayed with us to learn also from you as well. And if anybody has any questions, please reach out to your local detachments. If you have any questions and you're concerned about someone, it doesn't hurt to do a check on that well-being or call Crime Stoppers if you're concerned, as Kevin's last case here just sort of verifies that you don't know until you kind of go through that door and find out what actually is going on. So thank you all. I appreciate it. You're more than welcome to stay on for our last presentation for the day. And again, thank you very much. So we are now going to turn to our last presentation with Jane Meadus, a longtime colleague, who is going to be introduced by Laura. So welcome, Jane. And Jane has been very helpful in the back end, answering all our legal questions as we've gone through today. So thank you so much.
I was going to say that I kept going into the questions and seeing that Jane was already answering the questions being posed. So we appreciate your legal expertise in our chat box, because I certainly do not have that, Jane. So Jane is joining us this afternoon. I'm thrilled to have her with us. Let me just, as I am talking, we are pleased to welcome Jane Meadus, staff lawyer, and institutional advocate at the Advocacy Center for the Elderly, mostly known as ACE. Jane is a member of the Ontario Bar since 1993. She has spent over 30 years specializing in legal rights of residents within long-term care, retirement homes, as well as hospitals. Her expertise has been instrumental in major provincial proceedings like the Gillespie inquiry into long-term care. Sorry if my pronunciation was off on that. Some key highlights is she is a distinguished fellow at the Canadian Centre for Elder Law Studies. She is an award winner recipient of the 2022 Ontario Health Coalition Orville Thatcher Award for her commitment in improving seniors' care. Jane joins us today to provide expert clarity on access rights and resident rights within specifically long-term care as well as retirement home settings. Jane, welcome. We are absolutely thrilled to have you with us.
Thank you. Hopefully I'm going to get my slides up.
Yeah, take your time.
No, are you guys putting them up or
Oh,
do I do
Ryan?
that?
Give me 1 second.
I think you guys were going to do it for me. So I'll just start. So thank you very much. I have been sort of working in the background and making some notes. I did promise to answer one specific question, which I will do at the end of my presentation because it sort of comes at the end. So yeah, I work at the Advocacy Center for the Elderly. With respect to all this, the scam and that sort of thing, we did actually produce a series of videos with the issue of scams that are against the elderly. Those videos have, there's a bunch of videos that are by individuals who were scammed, telling their stories. And then there's a couple of videos by lawyers talking about what we see, what you can do about the scams. So I certainly encourage people to have a look at those. I'm hoping this is going to work for me. Let's see here. You've given me control. Oh, there we go. Or can I forward them or do I have to ask you?
You have to ask me, sorry.
Okay, that's fine. That's fine. Okay, so here I just pulled out. So I'm really going to be talking about access issues and what the rights are, because that's a question that we get a lot at ACE. We don't generally represent people in these cases, and I'll talk about that later. But it's certainly an area that I think is not only one where we get a lot of questions, but I think those questions are increasing. And I think there's an increasing use of trespass orders and similar types of prevention of visitors or people going out from these homes to go out and visit with others. And so that's what we're going to talk about today. So these are just a few things that I pulled off of the web with respect to various articles that have recently come up with respect to different homes and different people being barred from visiting their loved ones. I think all of these ones are probably in long-term care homes, but it happens in retirement homes as well. Next slide. So when we're talking about trespass, we're talking about the Trespass to Property Act, and that's the legislation which allows someone to be trespassed. And that differs from jurisdiction to jurisdiction. So we are talking specifically about Ontario. So if you're familiar with it in another province, it would be different. So I'm only speaking to Ontario. So the authority to trespass someone comes from the Trespass to Property Act, or the TPA. And only if the person has authority to trespass whoops, I didn't spell that right, can people lay charges. So that is really important. So we're going to be talking about what authority people have to trespass. When can a person be trespassed? Where are the issues? Next slide. So first thing we're going to do is look at what is the definition of an occupier under the Trespass to Property Act. So an occupier includes a person who's in physical possession of a premises. So that could be, the operator of a long-term care home. But it's also a person who has responsibility for and control over the condition of the premises or the activities carried on therein, or control over persons allowed to enter the premises. So even if there is more than, so there can be more than one operator, so, occupier. So you could have the operator, so the owner of the home being an occupier, but also the resident or the tenant is also an occupier. Next. So when is a trespass an offense? So they have to be a person who's not acting under a right or authority conferred by law. We'll talk about that. Without the express permission of the occupier, and the proof is on the defendant. So if you are charged with a trespass, you have to prove that you had a right or permission to be there. If you don't leave when you are asked, then you can be, if you don't meet those definitions, you can be asked to leave. And then if you are found guilty, there's a fine of not more than $10,000. Next slide. So if the person's been trespassed and the person refuses to leave, a police officer can arrest the person without a warrant if they believe on reasonable ground and probable grounds that there is a reason to do so, and that they're contravening Section 2. Next slide. So the mechanism, and I'm just going to give you sort of what generally kind of happens in these situations as I understand it. So generally what will happen in a long-term care home or retirement home is the occupier has to give notice. So it's usually the person that runs the home, so the landlord or the licensee will give the person who they want to trespass either orally or in writing notice. If the person doesn't leave, then they'll call the police, and the police have the authority to arrest the person and charge them under the Provincial Offences Act. And then you will receive a ticket and a fine. And that's generally what will happen. We'll talk about whether they actually have authority in all cases to do that. But that's sort of what, when we hear about these things happening, that's sort of the order of what happens. Next slide. So if you're found guilty or you plead guilty, you're going to be subject to a fine. You cannot receive jail time, but you can be charged anywhere between $50 and $10,000, and you can be placed on probation. And if you're found guilty by court, if you have damaged a facility, you kicked in a door or something like that, the court can award damages. Next slide. So there's no way to appeal the original order. And this is part of the problem that we run into from the get-go. So as I said, it's up to the defendant to prove that they didn't meet, that the occupier or whoever issued the trespass was wrong and that they had a right to be there. So there's no way to just appeal that. You can't go off and challenge that in court. Just because you get that order and that, or the notice or whatever from the from the occupier. So this is always the problem, because our opinion is that for the most part, many of these, if not almost all of the ones that we see coming to our office, probably are not valid. So in our opinion, generally, if the person is a visitor of someone in a long-term care home or a visitor of a retirement home, they don't actually have authority to be trespassing a visitor if they're an actual visitor of someone in the home. But if you get that, this is a problem, because there's no way to challenge that without being charged. So if you breach the order, so you get the order and then you go back in the home, then the police are called and charged. Then you can dispute the ticket. You can always plead guilty but ask for a lower fine. That's not usually in the cases that we're talking about, but that is available. You could meet with the prosecutor to see if they'll drop the charges. So you dispute the ticket and then you can ask them to drop the charges. I actually have never seen one of these go to trial or go before a justice of the peace. Every case that I'm aware of has been dropped by the prosecutor. So you can request a trial and plead, and either plead guilty or argue that, and then we'll see what happens. But as I said, part of the problem that we have in the retirement home and the long-term care cases is that they never go to trial. Because the charges are almost always dropped. I'm not aware of any that have ever gone to trial. So the Trespass to Property Act is a really blunt instrument. So if you have authority, so if it's your own home, for example, you don't have to have like a valid reason. It doesn't have to meet any kind of standards to prevent someone from coming on your property. So for example, I can say I don't like people with blue eyes, and I can put a sign on my front lawn saying no one with blue eyes may come on my property, and if you do, I'm going to call the police. And I've given you notice. So it doesn't have to be any kind of a valid reason if you have the authority over that property. And this is the problem, because how do you challenge that without getting charged? And that's the issue people always have, is they don't want to get charged. And even if you do get charged, you're still going to wait a year or longer probably to even get to court. It's a very lengthy process in our experience. However, they can't issue a trespass order if it contravenes the law. So, for example, you don't have to have a valid reason, but you can't do it if it would breach the Human Rights Code, or if the person has a right to be there for another reason, such as being allowed under statute or being an invitee of another legal occupier. And that's where we're going to go here is, do people in long-term care homes and retirement homes have a right to have these visitors? So it's, as I said, it's not uncommon for homes to issue trespass notices against visitors, including family members or substitute decision makers. We seem to be seeing more and more of them. And in our opinion, long-term care homes do not have the authority to restrict access by valid visitors. So they can certainly restrict, someone coming in from the street and sleeping in the stairwell, and they're not visiting anybody, they don't know anybody there. They can use the Trespass Property Act in that way, but they cannot restrict people who are actually visitors in the home. Next slide. So under the Trespass to Property Act, the resident is an occupier under the Trespass to Property Act. They have some control over their room. That's their home. The legislation is very clear that's their home. So they do have rights as an occupier. On top of that, under the Fixing Long-Term Care Act, which is the legislation which governs long-term care homes, they have a right conferred in that legislation under the residence right, which is number 6, which states that every resident has the right to communicate in confidence, receive visitors of their choice, and consult in private with any person without interference. So that means that the home may not interfere with the residents' visitors. And for this reason, we believe that not only are they an occupier, but they have a right to have visitors without interference by their landlord, and therefore the Trespass Property Act does not apply if it's a valid a visitor. Next slide. So you have a right to a visitor set out in the legislation. And I think I just basically said all of this. So it's really, it confers a right on that person. Next slide. So we are aware that both the Ministry of Long-Term Care has publicly stated that in some cases homes may trespass visitors. I have seen that in the newspaper, and I have also seen that in some cases. And the patient ombudsman has published things. I'm not sure where they stand on that. We questioned them on that before, and they withdrew from a conference when they were going to talk on that subject, but I do see that the material is still on their website. And they seem to believe that there's some sort of authority to have some sort of special circumstances to utilize the Trespass to Property Act in certain cases. I don't see that. I don't know where they can legitimately say that under the legislation. It is in direct conflict with both the TPA and the Fixing Long-Term Care Act, as well as case law, in my opinion. Again, I guess, someday somebody's going to challenge this and it will go to court and we'll see what happens. But in my opinion, in reviewing the legislation, there isn't anything in the Fixing Long-Term Care Act that says that you have a right to have visitors unless circumstances. There's nothing in there that says that. So we disagree with both the Ministry of Long-Term Care as well as the patient ombudsman if that's the position they're taking. Next slide. So the conclusion that we have is that residents of long-term care have an absolute right to visitors, both as occupiers and pursuant to the Fixing Long-Term Care Act. Homes have no authority to issue trespass notices, and the police have no authority to arrest or charge visitors, as the trespass notices are not valid under the TPA, and they should not be arresting people because they have to have reasonable and probable grounds. And if that person is a valid visitor and the home just doesn't want them there for whatever reason, they should not be enforcing the trespass notices. Next slide. So now I'm going to talk about retirement homes. I think there's some chats under there as well. Retirement homes are tenancies under the Residential Tenancies Act. They are not healthcare facilities. They are tenancies. The person who owns the building is your landlord. So tenants in a retirement home have the same right as any other tenant. There is nothing particularly special about that. Landlords do not have the authority to prohibit or restrict visitors, as tenants also have rights to have visitors as an occupier under the Trespass to Property Act. Next slide. So because they're tenants, they come under the Residential Tenancies Act, and any kind of restriction on visitors is a breach of the tenant's enjoyment of the property guaranteed under that legislation. And the legislation says that the landlord shall not interfere with the reasonable enjoyment. So they cannot prevent a person from having visitors if they so choose. They cannot include a clause in a lease reserving the right to bar visitors, because that is a right that the person has as a tenant, and you cannot put anything in there that's consistent with the RTA or its regulations. Next slide. So conclusion by us is that the tenant has an absolute right to visitors as occupiers. There's no authority for the retirement home to issue a trespass notice, and the police again have no authority to arrest or charge visitors if they breach these illegal trespass notices. Next slide. Oops, go back one. So what can you do if you or your visitor is served with a trespass notice? So if it's you who is issued with a trespass notice, we're not telling you to stay. You need to seek legal advice, okay? I'm not going to say stay and breach, and that's something that you really need to discuss with a lawyer. If you do breach, or if you're thinking, if you do get the trespass notice, I can advise that it's unlikely that you are going to get a free lawyer who can assist you, unless you know somebody who's a lawyer who'll do it, or someone in the private bar who's willing to do it pro bono. But you're not going to get a free lawyer. Now, if you're a resident of a long-term care home or a retirement home, and you are the person that's being prevented from having the visitors, so usually what we hear of is generally from family members or friends that are being barred from going in. But it is the right of the resident, not necessarily, it's not the right of the visitor, it's the right of the resident that we're dealing with here. If you're the resident in a long-term care home or a tenant in a retirement home and you're being prevented, you could seek legal advice from a local clinic like ours if you qualify for their services. And, for a local legal clinic, you have to be low income. But it's something that we would consider providing advice and in some cases representation. In one case, many years ago, pre-COVID, a gentleman had been barred from a long-term care home. He breached it. He appealed. He was challenging that trespass, and he was going to court. And we actually were applying to the court to be an intervener, so not a party to the case per se. So we're not representing anyone, but to argue the legal merits, because obviously, as I said, there's no case law. So we have a big interest for our clients to ensure that their rights are protected. And we prepared, motion documents, etc. It was a $95 charge, I believe, or fine, I should say. And as you can imagine, as I said, the prosecutor withdrew the charges, so it never actually went to trial, so we weren't able to do it. So if anybody did have a case that was going to trial, we certainly would be interested in potentially coming in as an intervener or something. But again, we would only represent possibly the resident or the tenant. Next slide. So what can homes do? So you're probably sitting there about, what happens if this person's there and they're terrible? what can the homes do? And that's what we hear all the time. So if the home believes that a visitor has committed an illegal act, such as assaulting someone or stealing, they can call the police. Okay. And then if the police believe there's evidence of a crime, they can lay charges. And I know there's a bunch of police officers on here, so I hope I got this all right. The police can issue a Form 10 undertaking when the person is charged. There would be conditions, including things such as staying away from the long-term care home or retirement home. So I have seen that happen where the visitor attempted to assault a staff member. The police were called and those conditions were included. And I believe that they would potentially later be confirmed by court in, in some of the preliminary appearances in court as well, or it could be put on later. The problem is that often the things that we're seeing, the reason that people are being trespassed is that they complain too much, or they yell, or they do say inappropriate things. And while some of this may be an employer issue, it doesn't allow the home to bar the person, as they are not crime. So yelling at someone is not necessarily a crime. Raising your voice, being inappropriate, like saying something that's maybe racist, not nice. We don't condone it, but it's not necessarily illegal. It's not a criminal offense. It is an employer problem for sure, but it is not necessarily. It doesn't hit the bar of allowing the police to prevent someone from going into the home. So the homes are definitely in a difficult situation, and they do have some other things where the home, there are some other situations where the home could bring different kinds of applications to court, and they would need to seek their own legal advice on that. Next slide. So some of you may have heard of Vula's law. And this is not legislation. It's not an actual law. This was a motion passed unanimously by the Ontario legislature, and I forgot to put what year it was. I think it was like 2016, but I'm not sure. And basically it says, in the opinion of this House, the Ford government should provide clear direction to operators that the Trespass to Property Act does not permit them to issue trespass notices to exclude substitute decision makers and guests of the occupants of retirement homes, long-term care homes, and other congregate care accommodations when they raise concerns about their loved ones' living conditions. It does not have the force of law. We don't think it requires the law, because we think that the law is clear that the residents and tenants are entitled to have guests. But this was brought forward after a very public case of Mary Sardellis, who was unable to visit her mother who lived in a retirement home. It was entirely illegal. And I know she still advocates on behalf of this issue. And I believe there was a marketplace show on it you could find on the internet if you're interested. But it is an issue that everyone sort of agrees sometimes, except when they think they shouldn't agree. And we really need to ensure that people are being properly educated, that we don't have things like the ministry, saying things like, oh, well, we're going to exclude the law in some cases and allow this to happen, or suggest that it happen in some cases. We really need to have more buy-in by the government to ensure that it's enforced. And if people think that this is not the way it should go, then the government has to change the law, not just ignore it. Next slide. So there have been some cases, they're not necessarily with respect to long-term care homes, when we're talking about occupiers. So I'm going to talk about a few cases that we have. So one is Cunningham versus Whitby Christian Home. This was the fact situation was this was just a regular tenancy. It was a low-income housing project. The landlord had previously evicted her boyfriend from the unit in the same housing complex. And when he came to visit her, the landlord issued a trespass notice against him, and the boyfriend stayed away. The tenant brought in application to the Landlord and Tenant Board for an abatement of rent due to the landlord's interference with the quiet enjoyment of her home. The decision of the court, because it went to the board and then to court, the decision of the court was that she was entitled to an abatement of rent as a breach of the covenant of her quiet enjoyment. that all tenants and occupiers had the right to invite persons without interference of the landlord, and the landlord could not use the Trespass to Property Act against persons who were invitees of tenants and occupiers. So this is not something, this is not just the ACE interpretation. This is the court's interpretation of what a tenant or occupier has the authority to do. Next slide. There's also a case called Carr and Ottawa Police Services Board. So in this case, a woman was sharing how I'm really condensed it's actually two decisions, one on the merits and then one on costs, lengthy fact situations. So I've really condensed it down. I know there was someone from Ottawa Police Services on, and I've really condensed it just to make it a bit simpler. But Roxanne was sharing a home as a roommate of her ex-boyfriend and paying monthly rent. She advised her boyfriend she was leaving at the end of August. Prior to the end of August, she was sitting outside with a friend when the police arrived. They spoke to her roommate, Morgan, and came to the conclusion that Roxanne was an unwanted person and arrested her, eventually handcuffing her and throwing her into jail naked. She sued the Ottawa Police Services and the individual officers involved for injuries suffered during the arrest, economic loss, and a breach of the charter. Next slide. It was held that she was a tenant and could not be arrested and detained pursuant to the TPA. Or in the alternative, she was a licensee, and that has to do with whether she shared accommodation and how the accommodation was. But if she wasn't a tenant, she was a licensee and still could not be arrested and detained. Although the interaction had gotten heated during the arrest, the police had no basis to conclude there were grounds to arrest her pursuant to the criminal code, and she was awarded over $254,000 in damages for false arrest, false imprisonment, excessive use of force, negligent investigation, and a breach of charter rights. And there was also $180,000 cost awards. So there's a case, it's not exactly with respect to, long-term care or retirement homes, but you can see that if things go wrong and that the police force, for example, could get sued, and I think long-term care homes could also get sued in these breaches, and there can be quite large sums of money involved in these cases. Next slide. So I think there's probably I think I just saw something go by about this issue. So restrictions on visitors by family or substitute decision makers, we see that a lot. We get that call quite a bit. Both long-term care homes and retirement homes should be extremely cautious when a third party, such as a family member or substitute decision maker, is attempting to restrict any visitors or bar someone from leaving the home with a visitor on an outing. Substitute decision makers generally don't have the authority to restrict visitors or restrict access to the residents in long-term care or retirement homes. The attorney for personal care may have authority if the person is incapable and it's a safety issue. So next slide. Whoops. So if the resident is mentally capable, they're the only ones who can decide whether or not they want to have a visitor. Capacity, geez, you can tell that I wrote this late last night. Capacity to have a visitor is very low, not low. And in most cases, there will be no third party with authority. So visitors does not appear in the hierarchy, so it's not under the Healthcare Consent Act. And in a power of attorney for personal care, the authority of an attorney has to come under one of the listed areas, and visitors is not one of them. Next slide. So guardian of the person has generally guardians of the person if they have authority appointed by the court. That's usually the most authority because they're usually full guardianships, although there are partial guardianships. So you have to look at the guardianship order to determine what authority that guardian has. And if the person seeking the guardianship knows this is going to be an issue, I think that they should include that in the guardianship order, and that would be a discussion they would have with counsel. So if they're applying to court because there's abuse and there are issues, I would think that they would want to have included in that guardianship order something about the visitation, etc. Next slide. So an attorney for personal care, as I said, only has the ability to consent on behalf of the person where it's under one of these areas. So healthcare, nutrition, shelter, clothing, hygiene, and safety, and where the person has been determined to be incapable with respect to that decision, pursuant to the requirements of the power of attorney for personal care. And I'm not going to get into specifically how you determine capacity. I will say this, under the health, if it's an issue that comes under the Healthcare Consent Act, you go to that act and you see how capacity has to be determined. If it's an issue with respect to one of the other things, so like nutrition, shelter, clothing, hygiene, safety, it is quite possibly the attorney that's making that decision. It does not generally require a capacity assessment, but it can, and you have to read the power of attorney to determine who makes those determinations. And it's quite complicated. So you need to read the powers of attorney. I know that there was a question earlier on in today about what happens if the attorney won't give you a copy of the power of attorney. And the answer is, if they won't give you a copy of the power of the attorney, they're not the attorney. Okay, you cannot accept, they have to provide you with at least a copy of that document. Some people, want a notarized copy to make sure it hasn't been changed, and that's fine. But at least you need to see a copy of it to review it and then decide whether or not you need more evidence or something. But you are responsible for getting consent. You're responsible for all sorts of things if you're getting that consent. And so you have to see a copy of that document. And I think we have a lot of trouble in the sort of the healthcare sector. People think that if they just say I'm the attorney for personal care, or usually they say they're the power of attorney is actually the document. But if they say I'm the attorney for personal care, everyone thinks they should just accept that on face value. If I walked into a bank and I said, hi, I'm my mother's power of attorney for property, give me $100,000 out of the bank, they're not going to do it. They're going to want to see the document. They're going to want to read it. There's all sorts of due diligence they need to make. There's no difference if you're the attorney, except in sort of more emergency cases. So obviously you have to look at the situation. If the person says, I'm the attorney, and the patient needs surgery right now, you have to make a decision whether you'll accept it from that person on their say-so. But in general, most decisions, you should be getting a copy of that power of attorney. And even if you make that decision, you accept that consent on their say-so because it's an emergency, I would still want to get a copy later. And so if they refuse to give it to you, I would not accept their consent on that basis. So if there's no power of attorney, a substitute decision maker under the Healthcare Consent Act, that's the hierarchy, would not have any authority to determine visitors. That is not one of the enumerated things under the Healthcare Consent Act. So they would have no authority to decide yay or nay on visitors. Next slide. So there actually was a recent case that did talk about consent to visitors, and this is a case called Or and Or, which came out in 2025. William was a resident of a long-term care home, and his wife Gwen was acting as his attorney for property and personal care. There had been some finding of incapacity of William for property and personal care in the past. And again, you have to remember that while a finding of incapacity with respect to property is generally an all or nothing, and you don't necessarily need a capacity assessment. If there is a power of attorney, you have to look to the document to see when it's valid. And if there's some kind of a springing clause that says what you have to do if the person's incapable. But power of attorney for personal care is issue by issue basis. So a person can be capable for some things and not others, at some times and not others. Just think about if you are unconscious because you're in a car accident, you're not capable, you have the surgery, you're fine. Of course, you gain your capacity back. So capacity is not an all or nothing thing. Gwen and William had two children, Allison and Nathan, and there'd been a falling out in the family prior to his admission to long-term care. Gwen ordered the home to bar Allison and Nathan from visiting. The home refused to put any restrictions on the visitors, as they indicated that William had deemed capacity to make that decision and that they would comply with that. Gwen commenced an application to court. The court held that the court declined to order an assessment of capacity as it was not needed. They held that William had expressed a wish while capable to see his children. Further, there was nothing in the power of attorney for personal care that restricted visits despite them having been estranged at the time of its writing. There was no evidence of any harm coming to him from his children, for which he required protection. And the court gave directions that Gwen was to give Allison and Nathan access to visit with William. It's a very interesting case. I think people should read it. But I think it's sort of one of the few cases where we're looking at where we've been able to get sort of some instruction from court on that authority. Next slide. Restrictions on residents leaving with third parties. A home doesn't actually have any, whether it's a retirement home or long-term care home, they don't have any detention authority. So except in an emergency situation, there is some detention authority. So generally they don't have the ability to prevent anyone from going out with a third party. Attorneys for personal care really don't either have any authority to detain unless it's something called a Ulysses contract. That's a special kind of power of attorney where you have to have a special kind of a capacity assessment before. Generally, you don't need a capacity assessment to sign a power of attorney. Capacity assessments are sometimes done where lawyers think that there may be some kind of a challenge, but frankly, if I'm as a lawyer, it's up to me to decide whether my client is capable or not capable of giving a power of attorney because I'm the one that's doing the work. But very often, if it's a family dispute where you know it's going to be challenged in the future, they may go and the lawyer may get a capacity assessment just to have that information in their files in case there's any disputes in the future. And again, substitute decision makers don't have authority to consent to detention and prevent a person from going out. So that's long-term care. And of course, landlords don't have a detention authority either to detain their tenants. This is not the topic of the conversation here, but certainly there is actually in the Healthcare Consent Act and the Fixing Long-Term Care Act, there are sections that deal with the potential legal authority for homes to detain. Those sections have been passed but never enacted, so they actually have no force and effect at the moment. I would love the government to enforce them because I think that it is needed. We have people in long-term care who should be detained for their own good. And at the current situation, actually, the homes don't have that authority. With respect to retirement homes, there are more and more people in retirement homes who have capacity issues. There was a reference to, somebody wandering out in the street in -40. That's a case that's going on at the moment. And, it's very challenging because these are tenants and there is no authority to detain. If that person had been in just a regular apartment building, not a retirement home, it wouldn't have been actually an issue if they'd gone out and frozen. It would have been terrible, but not necessarily an issue that the landlord could have been, gone after. So it's definitely an issue. One question that I had that I did want to talk about was with respect to a person in a psychiatric facility who's incapable and can somebody who's an attorney under a power of attorney for personal care restrict visits from friends or family, etc., or prevent updates. So in a psychiatric facility, if they're being detained in a psychiatric facility, it would be up to the psychiatric facility to make those kinds of determinations if they're under a form. There's nothing that the attorney, it's no different in that situation. Hospitals can use the Trespass to Property Act because it's not the person's home. There's a real question, and I've had one case where someone was in a chronic care facility where they lived there, and the court was not happy when someone was trespassed, I can tell you. There was never any decision because the hospital immediately withdrew the trespass order once it got in front of the court, and so it never went to a case. With respect to updating information, if the person is capable, it's up to them to decide who they will share the information with, and this is anywhere, can be in any context. If the person is not capable, it's the person who is their decision maker pursuant to the Personal Health Information Protection Act, which governs the authority to access records. So it would depend on who has that authority, and they can restrict that access if the one child has a power of attorney for personal care and the person is incapable of the family member is incapable of consenting to the release of information, that attorney does not have to share the information with the family. There are some requirements under the Healthcare Consent Act about allowing visitors and stuff, but not necessarily mandatory to provide all of the records and information. So I think we're at 2:30, so I'll stop talking.
Excellent. Thank you so much, Jane. There's so much to cover, I think, in the legal and understanding all the dynamics that go with understanding the laws. And we did a great job sort of explaining that, and knowing that you're a great resource in dealing with many of these cases. We do appreciate sharing your expertise. We had a couple questions that we have a few minutes to do. Somebody was saying, can homes like restrict a visitor from speaking to the staff specifically, like asking questions? Because you had mentioned that sometimes that's the reason why they get trespasses, like they ask too many questions. So can they say, when you come in, just don't talk to us, or don't ask questions?
That's, the legal authority there, I think, is pretty tenuous. I don't know how you can prevent somebody from asking questions. And frankly, I mean, it's up to they don't have to answer. But again, the visitor can go in and, since our opinion is that the home can't trespass them, I don't know what mechanism they have to enforce that. They just don't have to answer the questions. We see that a fair amount. Often, when there are issues of this type, what I do recommend is for the home and the person that's, it's usually a substitute decision maker, is, they're having some kind of conflict. And I suggest that perhaps, because there are so many concerns, that they set up a specific person in the home that's sort of the point person, and often set up, frequent meetings. So like once a week or once a month or whatever works out. But there's certainly obligations of health practitioners to speak to a substitute. So if it's with respect to a health practitioner, so that would not be a PSW, and that person is acting as the substitute, I don't see how they can refuse, but I do know it's an issue, and we do try to make suggestions of how to make it a little bit easier.
Yeah, I think that's a good suggestion.
There's another question here, Jane. Somebody's hoping that you could elaborate a little bit more when you mentioned that lawyers can decide for themselves if their client is capable or not.
Yes.
So the individual is just looking for you to elaborate on that.
Okay, so there is the capacity assessors only have legal authority in a couple of very limited situations. So they do capacity assessments under the Substitute Decisions Act when they're requested to start a statutory guardianship. And they also have legal authority if a power of attorney, whether it's property or personal care, requires an assessment by them, or just says it requires an assessment, doesn't say by who, to invoke the power of attorney, the clauses. They have so it's anything else that a capacity assessor does. And we're talking about capacity assessors who have a license or who are authorized under the Substitute Decisions Act. They actually have very limited roles. They are usually, a lot of what they do is, as I said, sort of a backup kind of assessments. So it would be, and I know this was a question to the police, so it's something about, well, what if you think they're incapable? And one person said, well, we decide whether the person's capable, and the other one says we send them to a capacity assessor. My opinion is that the police, if they're trying to get discussions with the person, it would be up to them to decide whether or not that person is capable. That doesn't mean that they're NCR, it doesn't mean, it's really just for that purpose. So if you're if you're going into a contract, for example, if I'm a car salesman and someone comes in, I have to assess whether the person who's trying to buy the car is capable. And if I take their money, and we saw earlier today with people, the Crown talked about someone coming in and clearly person was incapable and getting them to sign, documents and stuff. That person knew that person wasn't capable. They, didn't need to be told that. They very likely knew that. And it's the person who was getting that signature. It's up to them to decide whether they're capable. And if they make, if they're going ahead anyway, it's going to be a problem. Health providers, they have to make their own decisions around treatments that they're providing. So it's really, there's very limited use of capacity assessors. And I think people send everybody to capacity assessors all the time, and it's way too much. We do have to have our own opinions when we're the person that's getting that consent. And I think people really need to understand that.
Yeah, there was a question around the capacity assessment. Like, is one doctor's assessment for capacity enough, or you had alluded to it, but who initiates it? And it can be, I guess, anybody. The senior has to agree to have that assessment as well. They can refuse to do the assessment, if I'm correct.
So yeah, so in most cases, unless it's ordered by court, a senior never has to undergo a capacity assessment. And so that's certainly, something that they can refuse. Doctors are often asked to give opinions around capacity. So if they're asked, is my mother capable of managing property? Unless there's a power of attorney that says this power of attorney cannot be used unless my doctor is of the opinion that I'm incapable, their assessment is of no value. It's an opinion, but it doesn't have any legal authority. I can write a power of attorney and say that I'm going to ask if the person who has to make the decision as to whether I'm capable is Rayanne. I can put that in a power of attorney, and it's up to Rayanne now, in someday in the future, hopefully, to determine my capacity. I can put that in there, and that's valid. So capacity assessors are actually very limited. And doctors, I see doctors' opinions, I see doctors' letters all the time that say they're incapable of everything, or, and there's no such thing as global incapacity when it comes to personal care. And we see that a lot, especially in doctors' notes. Doctors have authority. If they're psychiatrists in a psychiatric facility, we don't need to talk about that. And health practitioners, whether they're a doctor or whatever, if they're offering a treatment, it's up to that person, the doctor or the nurse or the massage therapist or whatever it is, to determine whether or not their patient has the capacity to consent, not sending it to a capacity assessor or psychiatrist. Their opinion.
I have another interesting question that popped up in the Q&A, and maybe post you can answer some of these questions. I'm not surprised, Jane, that we got blasted with questions for your presentation. So somebody is wanting to know if a home long-term care retirement can restrict a visitor from speaking to staff or frontline staff.
Yeah, I just sort of answered that. And again, if it's not for the purpose of getting, a consent or getting information, if they're not the substitute, or if the person isn't a health provider, maybe. But, if that person's asking questions because it's a care issue, I think that they don't have that right to do it. But it's complicated.
The other question around powers of attorney we often get, even when we get calls, is the senior may live here, but the power of attorney is in BC or something. Mm-hmm. So is there any laws that saying that the substitute decision maker or the person that you dedicate as your attorney has to live in the same city, province, or country as you that live there?
No. The answer is no. And I think that there was a question about if somebody in jail could be a substitute. Absolutely. I don't see that you don't have to be a good character, as we know, and that's why we have problems with powers of attorney. Mm-hmm. And a situation could arise, for example, where someone is in jail and is the attorney for property, for example. Now, they may not be able to do it, so they could resign. If there's an issue, the mechanism is for someone to go to court and overrule it. There's nothing that says a person in jail can't do it. Because they could be in jail for drunk driving. It could have nothing to do with anything. They could be in for, weekend sentences. I don't know. There's no broad brush that says that anybody can't be. They can be the substitute for healthcare for their family member. And you can certainly name somebody in other provinces, other countries. I've seen people in the consent capacity board. We had a case here many, many years ago we were involved in where our client, the family applied from Germany to be the decision maker under the Healthcare Consent Act, and we're authorized to do that. So there's no requirement that they be here. If it's a court application, And the child lives in the US, I think the court's probably going to, it's going to really depend. I think they have a bigger uphill to climb on that, but it wouldn't be impossible.
I think the one thing, just to clarify, you can't, if you lived in BC and you moved to Ontario, your BC power of attorney does not transfer to Ontario. Is that correct?
No, it does.
It
It does
Okay.
transfer. It does
Okay.
transfer with qualifications. Okay. So, for example, I was a co-attorney for my great aunt. She moved from Toronto to Newfoundland. She had an Ontario power of attorney. We were able to utilize that power of attorney for property and for personal care in Newfoundland. So it can, but there may be different limitations, and it as long as it's valid where it was signed, it is probably valid here. But as you can imagine, as a lawyer, I have to say there's a lot of exceptions to those rules. And even from other countries, there's potential that it could be valid here. But we certainly, if you are a snowbird and you're going from here to Florida, we would recommend that, you probably want to have a power of attorney in Florida and one here, but you'd have to write them properly because generally powers of attorney revoke the other one.
Right.
And so you have to be very careful. But I think it makes it easier if they're in that jurisdiction. But there's, all rules around laws around back and forth those things. But I have certainly seen them from other countries as well be valid here.
And one last question, just about the services from ACE, if someone is reaching out for help. So if I have a situation where I'm concerned about someone who's incapable and they're not able to actually phone and consult with you, can the POA or substitute, can they contact you for services on behalf of the person that they're concerned about or that they're an SDM for?
Sometimes.
Okay.
The answer is sometimes. It depends on the issue. It's sort of on a case-by-case basis. I would say in the vast majority of cases, it's usually the person. But for example, I deal with long-term care homes and hospital issues. So a large, not most, but a large portion of my clients are incapable and we are taking instructions from substitute, but it depends on what the issue is and all of that. But if you called and you said, my mom's incapable and the home won't let me visit, we will not take that on. You would have to go to the private bar. So we won't represent because the issue isn't with mom, the issue is with the person visiting. And so we would not take it on even if mom's incapable.
Great. Okay. Thank you for clarifying.
And I'm gonna correct the slides and all the errors that I saw that I made this morning.
Okay.
And then I will resend them to you and you can send them out if you like.
Perfect. Thank you so much. I appreciate Jane, you coming today to share your wealth of experience. And I know this is an ongoing topic that will continue to be, something that we may come back to and host another session on. Jane is also coming to that LEAPS conference to talk about this issue as well for the policing piece that we talked about. So thank you again, Jane, for sharing your information, and we will post those the slides for you as well. So thank you for coming, and we appreciate you taking the time because I know you're so busy. So and people, please go to the website, and as Jane was referring to, that they do have those new videos around frauds and scams that they've just produced as educational tools that you can access and learn from other victims of actually telling their stories, so people can learn around that prevention piece. So take advantage of lots of the resources and information on the ACE website. So thank you.